quoted. So Lady Hale and Lord Reid go on to consider the application of constitutional principles to prerogative powers, which was what that case was about. But what I'd like to draw attention to here is this. Firstly, the separation of powers as a constitutional principle and the role that the constitutional principles have in regulating the relationship between public bodies. In this case, it is the relationship between the Scottish Parliament, a legislature with an unquestioned mandate to make laws for Scotland, and the UK government, an executive which does not have policy responsibility for gender recognition in Scotland, that having been allocated to the Scottish government by the UK Parliament. And as the prorogation case made clear, the court has a role in giving effect to constitutional principles so as to regulate relations between other parts of the state. The reference to Fire Brigade Union is to the well-known speech of Lord Mustill. That's on the second page of my outline speaking note, lady, and that's also worth turning up. And it starts at the PDF page 416. And it says this: interpret the laws and see that they are obeyed. This requires the courts on occasion to step into the territory which belongs to the executive, to verify not only that the powers asserted accord with the substantive law created by Parliament, but also that the manner in which they are exercised conforms with the standards of fairness which Parliament must have intended. Concurrently with this judicial function, Parliament has its own special means of ensuring that the executive, in the exercise of delegated functions, performs in a way which Parliament finds appropriate. Ideally, it is these latter methods which should be used to check executive errors and excesses, for it's the task of Parliament and the executive in tandem, not of the courts, to govern the country. In recent years, however, the employment and practice of these specifically parliamentary remedies has on occasion been perceived as falling short, and sometimes well short, of what was needed to bring the performance of the executive into line with the law, and with the minimum standards of fairness implicit in every parliamentary delegation of a decision-making function. To avoid a vacuum in which the citizen would be left without protection against a misuse of executive powers, the courts have had no option but to occupy the dead ground in a manner and in areas of public life which could not have been foreseen 30 years ago. So, as I've set out in my note of argument, a lady, at the time the Secretary of State informed the House of Commons of his decision to make the order, his reasons were not published, and a resolution seeking annulment of the order was tabled, but time was not allowed to debate and vote on it. And that's, the reference I make there, my lady, is to the UK Parliament early D motion, which is week 16, a process, but at page 397 of the PDF. And the reference is made there to the House of Commons Library Research Briefing, and heading the Secretary of State's veto and the Gender Recognition Reform Scotland Bill of April 2023. So whilst a resolution seeking to annul the order was tabled, time was not allowed for the debate and a vote. So in those circumstances, we are, to use Lord Mustill's metaphor, in the dead ground. We're occupying the dead ground and stepping into the vacuum to seek to protect against misuse of executive powers. It is, for the reasons he sets out, appropriate that the court ensure that the delegated power contained in section 35 has been properly exercised. I will return to this later, but I can also raise the point now that I do not accept the Advocate General's submission that this is a decision which is not, in substance, amenable to review by this court. The continued development of judicial review which is acknowledged by Lord Mustill in the final sentence, has continued in the near 30 years since he delivered that speech. In my submission, this court, my lady, should not feel inhibited in reviewing the Secretary of State's decision to make the order. On the contrary, this court has, in my respectful submission, a constitutional duty to do so. It is perhaps convenient then to deal now with the point taken by the Advocate General about the reference to proceedings in Parliament. I'll return to the use of Hansard when considering the interpretation of Section 35. It is in my submission proper and appropriate to make reference to parliamentary proceedings for the purposes of establishing matters of historical fact. I doubt that that proposition will be disputed, but lest authority be required, it is the case of our Heathrow Hub against Secretary of State for Transport, which is number 7 on the joint list. The relevant passage is at paragraph 158, which is at page 464 of the PDF. That is the purpose here, to establish the historical facts. These are matters of historical fact that the respondent does not dispute. The very limited parliamentary involvement in scrutiny of the Secretary of State's reasons for making the order forms part of the context in which the court should review the lawfulness of his decision. So, as I'll come on to submit when I turn to address the construction of Section 35 of the Scotland Act, it provides for executive veto of intra-virus legislation which goes against the grain of the separation of powers. That, I will submit, points towards the exercise of that power being narrowly construed and tightly controlled. The second principle I want to say something about is parliamentary accountability. That is a constitutional principle no less fundamental than parliamentary sovereignty itself, that has been recently made clear by the Supreme Court in Cherry. I refer again to paragraph 46 of Cherry at PDF page 355. The reference is for your ladyship's notes, as I don't think we need to turn it up. But the point is this: having largely transferred executive responsibility in respect of non-reserved matters to the Scottish Government, the UK Parliament intended the Scottish Government would be accountable to the Scottish Parliament for policy choices in areas within devolved competence. In that way, the constitutional principle of parliamentary accountability is fulfilled. Policy responsibility and political accountability for reserved matters remains with the UK Government and Parliament. It would be inconsistent with the constitutional principle of parliamentary accountability for the UK Government to be able to veto Scottish legislation simply on the grounds of a policy disagreement. As will be clear from the next part of my submissions, Section 35 was never intended to and does not give the UK Government such a power.
You say, Lord, that's what this essentially amounts to. It's a veto on the grounds of a policy disagreement.
Exactly. That's exactly the position. It's a veto that's inconsistent with the constitutional principles that we all recognise. So before parting with Cherry, I would invite your ladyship to notice what is said by Lady Hale and Lord Reid. It is a major theme of the Advocate General's note of argument that the decision to make an order under Section 35 of the Scotland Act calls ultimately for a political assessment, and so it's inappropriate for my lady to review, or at least review with any intensity, such a decision. Against that background, I would ask your ladyship to turn up paragraph 39 of Cherry, PDF page 354, and if you pick up paragraph 39 halfway through at the word nevertheless, my lady will see the powerful reasons I have for making reference to this part of the decision of the Supreme Court. It says, nevertheless, that is the UK Constitution, includes numerous principles of law which are enforceable by the courts in the same way as other legal principles. In giving them effect, the courts have the responsibility of upholding the values and principles of our Constitution and making them effective. It is their particular responsibility to determine the legal limits of the powers conferred on each branch of the government and to decide whether any exercise of power has transgressed those limits. The courts cannot shirk that responsibility merely on the ground that the question raised is political in tone or content. That last sentence, my lady, is particularly clear and is a clear answer to the suggestion made by the Secretary of State that this is a political issue and inappropriate for judicial consideration by my lady. As the Supreme Court says, the political tone or context does not permit the court to step back and sit on the sidelines. That then is the constitutional context in which Section 35 falls to be considered. I now turn to Section 35 itself. The correct interpretation of Section 35 of the Act is reflected by the ministers at page 13 to 23 of their note of argument. The proper interpretation of this piece of legislation, Section 35, has never before been considered by the court. Since the wording lies at the heart of this case, my lady, can I ask you to read the key parts? The provision is at page 20 of the PDN, and it's set out in Statement 23 of the petition. And it's obviously in the outline speaking note for ease of reference. Section 35 says, the power to intervene in certain cases occurs, 1, if a bill contains provisions which make modifications of the law as it applies to reserved matters and which the Secretary of State has reasonable grounds to believe would have an adverse effect on the operation of the law as it applies to reserved matters. He may make an order prohibiting the presiding officers from submitting the bill for royal assent. The order must identify the bill and the provisions in question and state the reasons for making the order. So the order has to identify the bill and state the reasons for making the order. The order may be made at any time during the period of 4 weeks beginning with the passing of the bill. An order under Section 35 is subject to annulment in pursuance of a resolution of either House of Parliament, and that is Schedule 7 of Paragraph 1 of the Scotland Act, and that's in the supplementary bundle that was passed up this morning. Reference is made at Paragraph 14 of the note of argument to ministerial statements made during the passage of the Scotland Act in relation to what became Section 35. I understand that exception is going to be taken to them. So it is appropriate to start by addressing the test for referring to such material. That, of course, is set down in Pepper and Hart. I'm sure my lady is very familiar with that case. That's a copy's in the supplementary bundle, not in the core bundle. And it comes in 3 parts, and it's set out by Lord Wilkinson. The test is set out by Lord Wilkinson at page 640, which is PDF 238. I don't understand there's a disagreement over the test as opposed to its application, so I'm not planning to turn it up, but the test is threefold. Firstly, the meaning of the provision is ambiguous. Secondly, the statements are made by a minister or other promoter of the bill, and the statements relied upon are clear. Those tests are met. The meaning of Section 35 is, in my submission, ambiguous. The passages I'm going to come onto in relation to ministers responsible for the passage of the bill, and those statements are clear. And again, I'd refer to Lord Brian Wilkinson's test at page 640. I understand that it's the first test, that's whether Section 35 is ambiguous, is the issue to be contested. To be frank, I am surprised reference to these statements is controversial. And I've included, therefore, in the Supplementary Bill of Authorities, the case of reference re the recovery of medical costs for asbestos Wales Bill case and the Wilson against First County Trust Limited case. And perhaps my lady could just...
I'm not sure, Lord, I'll need to hear obviously in due course from Mr Johnson, but it may not be so much whether reference is ambiguous, but the purpose for which reference is made may be more well, if there is a difference between you, it may be that rather than because, as you quite rightly say, it's accepted, for example, for as a matter of record of historical fact, that's perfectly appropriate, for example. So it may be, as I say, we'll come on to find out really how controversial it is, but it may be the use you choose to make of it rather than the fact of reference to it itself.
So I'm not going to refer to these authorities, and it might be that your ladyship would allow me to respond in due course if that's appropriate. So I just move on.
Yes.
So assuming your ladyship is satisfied she can properly look at the statements, they are indeed, in my submission, worth turning up. The first is an answer given by the then Secretary of State for Scotland, the Right Honourable Donald Dewar MP, during the House of Commons report stage of the Scotland Bill on the 12th of May 1998. This is item 11 on the petitioner's bundle and is marked up in the documents at PDF 448. In the entry at the foot of the page, Mr. Dewar is responding to a question about judicial review. References to the 1978 legislation are to the Scotland Act 1978, which of course contained a different scheme of devolution, which of course was not implemented. Mr. Dewar says the judicial review would be taken in the Court of Session in Scotland. It would be a challenge from Scotland and would be dealt with by the Scottish courts. There is an important distinction between the Governor-Generalship powers, as they are sometimes called, under the 1978 legislation, and the powers of the bill, in the bill. Under the 1978 legislation, the Secretary of State could have intervened on the basis that he didn't like the policy that was being followed by the Scottish Parliament. The bill provides an important qualification. It is no good the Secretary of State pleading that he doesn't like the policy. It must have an adverse impact on reserved powers. That is a sharp distinction. Whilst any judicial review would not necessarily have to be brought in the Scottish courts, we can see here that the Secretary of State responsible for steering what became the Scotland Act 1998 through the House of Commons, explaining that what became Section 35 contained a power which would be amenable to judicial review and that it was not a policy check on the devolved legislature. That is consistent with how I say Section 35 should be approached. I'll come back to that when I've finished with the parliamentary material. The second significant parliamentary statement was made by Lord Sewell, then the Parliamentary Under-Secretary for the State of the Scottish Office, and so responsible for steering the Scottish Bill through the House of Lords. And he spoke in the House of Lords on the 28th of July 1998. That is 6.19 in the second inventory of productions and PDF page 267. It is much longer and I'll not read it in full. But starting with the second paragraph, he said this: while for the Scottish Parliament to have a workable legislative competence, its legislation for devolved purposes needs to be able to have ancillary effects upon reserved matters. The government recognise that there need to be safeguards in cases where the acts of the Scottish Parliament could have an adverse effect on the law as it applies to reserved matters. For example, legislation about housing or local taxation could possibly have an impact on the operation of social security legislation. Clause 33, which became Section 35, therefore empowers the Secretary of State by order to prevent the Scottish Bill from being submitted for royal assent in certain circumstances. Moving on to the paragraph third from the foot of the page, he said, these powers of intervention are, of course, meant to be long stops. Their use would require to be justified and would be liable to be scrutinised by judicial review. The amendments establish a series of tests which limit the extent to which legislation by the Scottish Parliament can affect reserved matters. But the powers of intervention provide essential balance to ensure that there's a sensible outcome in relation to reserved matters. Their existence should be sufficient to ensure consultation between Whitehall and Edinburgh, so there may be no need for them to be used. But there should be no doubt that this government would be willing to use the powers of intervention if it became necessary. Again, similar themes emerge, and it's expressly described as a safeguard and a long stop. So for my part, my lady, based on those statements, 6 propositions about what became section 35 are set out at paragraph 14 of the note of argument. And I would state these here. Firstly, the exercise of the power was to be subject to important safeguards. Page 4 of my outline speaking note already. Secondly, a reasonableness test was intended to be built into section 35. The exercise of the power would be subject to judicial review, in which the courts would have to consider the adverse effects of such an order and apply the reasonableness test. In contrast to the so-called Governor Generalship powers under the Scotland Act 1978, under which the Secretary of State could have intervened on the basis that they did not approve of the policy adopted by the Scottish Parliament, the Secretary of State would be entitled to intervene only if there was an adverse impact on the law as it applies to reserved matters. The power of intervention was intended to be a long stop, and the existence of the power should be sufficient to ensure consultation between Whitehall and Edinburgh, so there may be no need for them to be used. That last point touches on something I will return to, but which I'll introduce now. It is mentioned repeatedly in the Advocate General's answers and note of argument that he only had 4 weeks to take a view on making the order. But he wasn't working from a standing start, and that was expressly recognised during the passage of the Scotland Bill. The fact that at the end of the process a veto could be exercised was meant to ensure consultation to resolve such issues. If the consultation had any prospect of resolving matters, it had to be before the bill was passed in its final form. In other words, the sort of cooperation anticipated in the Memorandum of Understanding, which I will mention shortly, was anticipated by those debating what became Section 35. I will return to this, but I do make the point that if the Secretary of State had such fundamental concerns about this bill, it is striking that there was not a whisper of them through the various consultations and in the earlier stages of the bill's parliamentary process. Indeed, the UK government got sight of this bill and the appropriate supporting documents before the bill was introduced to the Scottish Parliament. And there's long-standing conventions between the Office of the Lord Advocate and the Scottish Government's Legal Department and the Office of the Advocate General that there are extensive discussions about legislation in relation to issues of competence, lawfulness, etc. in the long course of period of time before the bill's debated in Parliament and then passed by Parliament. And that long course of consultation did happen, and I can provide a chronology of all the communications and meetings that happened, but never once during that was the spectre of Section 35 raised, or the issues raised by the Secretary of State in the order explored in detail with the Scottish Government.
I'm sorry to interrupt your flow, Lord. It's a point that interested me when I was reading through the papers. I'm not clear of the significance yet in my own mind, if at all, of this point, and I don't know if at this stage you're able to help me. And if you want to return to this later, please do feel free to do so. But I can certainly see that it could be argued that if there were thought to be these fundamental problems, one might put it simplistically as a matter of courtesy, if nothing else, that it might have been raised in specific form beforehand. But of course, the language of Section 35, and we're in a situation where this has never been looked at before, but the language of Section 35 doesn't require consultation. And I completely understand that a matter of convention, a matter of policy, it's in the Memorandum of Understanding. But it doesn't, for example, say that the Secretary of State may, after consultation or something of that order. So there's no absolute requirement in Section 35 that there be notice in effect, or it could have said, for example, due notice having been given or something along those lines. So other than, as I say, there might be disquiet, upset, anger even that this was not fleshed out in more detail. How does that assist in deciding the lawfulness or otherwise of the ultimate exercise of the power, other than being perhaps very important context and background? Yes. As I say, if you're able to help me now, that would be of assistance, or you could perhaps return later if that suits you.
I could return later to it, but my lady has a point that the Memorandum of Understanding that underpinned, that essentially thought to underpin the processes set down in the Scotland Act was a very significant document, but it's not legally binding, it's of no legal effect. And the order is as my lady states, the terms of this Section 35 order is as my lady states. But there is an important context, I think, that I highlighted earlier, which is the ensuring that the devolution settlement is workable and ensuring that we have a consistent approach to issues that impact on that devolution settlement. And having a situation where 4 weeks after the bill's passed in Parliament, that the Secretary of State can take that decision to veto is significant. And it's something that he relies on in terms of timing to explain the content and the adequacy of his reasons. So whilst it's not relevant interpretation of Section 35, it is a very important context that
Thank you.
that I rely on for. Returning to Section 35 then, lady, and setting the scene. Your ladyship should also notice that the terms of the Memorandum of Understanding between the UK government and the devolved administrations, that the power was also seen very much as a matter of last resort. And that was subsequently confirmed by this document, which is item 4 in the petitioner's marked up documents, beginning at page 105. The relevant passages are in paragraphs 27 and 28 at the PDF, page number 114 to 115, and that's at page 5 of my outline speaking notes. And I just think it's this important that in referring to the various powers of the Secretary of State and the law officers to intervene in devolved matters, which include Section 35, the Memorandum of Understanding stated that although the UK government is prepared to use these powers if necessary, it sees them very much as a matter of last resort. The UK government and the administration concerned will therefore aim to resolve any difficulties through discussion so as to avoid any action or omission by the devolved administration having an adverse impact on non-devolved matters. If formal intervention should become necessary, the UK government will, whenever practical, inform the devolved administration of its intentions in sufficient time to enable that administration to make any representations it wishes or to make any remedial action. And we know that that didn't happen here. So with reference to the Advocate General's observations about the Memorandum of Understanding, there's no dispute that it's not legally binding, and they do not invite your ladyship to reduce the order on grounds of non-compliance with it. However, it is in my submission permissible, indeed quite appropriate, to notice the terms of the memorandum for context and for the undoubted fact that its terms are consistent with the clear parliamentary statement that the power of Section 35 was to be seen as a long stop. The Advocate General makes various averments about what would normally be done in terms of reviewing bills and responding to consultations of devolved administrations. He invites your ladyship to have regard to what he says is normal in the practice of operation of government. My submission is this, my lady: he cannot cherry pick. If he wants your ladyship to have regard to what normally happens, then he can't ask your ladyship to ignore the Memorandum of Understanding. This memorandum assists your ladyship in understanding what the various governments consider to be the expected conduct of intergovernmental relations. It highlights not what not said and not done by the UK government in respect to this bill, and it puts in better context the plea that we only have 4 weeks. So in summary, yes, the memorandum is not legally binding. It's not a direct aid to the interpretation of Section 35, but it's understandably and undeniably part of the relevant constitutional context. And it is, in my submission, plainly open to your ladyship to notice the almost complete failure to engage with both the terms and the spirit of the Memorandum of the Understanding on the part of the UK government in respect of the bill. If concerns as supposedly fundamental as are relied on in support of the order arise, it is more than a little surprising that we got so far through the legislative process before they were raised. And finally, I make no apology then for taking a pleading point that the Advocate General denies the averment in paragraph 10 of the petition that at no point did the UK government identify concerns which might cause it to make an order under Section 35. But he makes no averments, having been called upon to do so, explaining when such concerns were made. That averment ought properly to have been admitted, or averments made about when the concerns were raised. And I say it is conspicuous that the Advocate General has done neither. So, my lady, the wording of Section 35 is analysed in paragraphs 15 to 23 of the note of argument. And in summary, it contains 3 conditions which must be satisfied in turn if an order made in reliance upon it is to pass the test of lawfulness. By that I mean, condition 1 is not satisfied, one need go no further. The order is unlawful. Similarly, if condition 2 is not satisfied, there's no need to consider condition 3. In other words, the conditions are cumulative, each is a necessary condition, we're making a valid order. So taking these in turn, lady, condition 1 contains provisions which make modifications of the law as it applies to reserved matters. Although modification is not defined in the Scotland Act, the interpretation section, that's section 126, PDF page 34, provides that modify includes amend or repeal. The word modification itself is defined in the Communications Act 2003. That was again put up this morning, lady, where it's provided that modification includes omissions, alterations and additions, and cognate expressions are to be construed accordingly. So since the provisions of the Scotland Act are to be given their ordinary and natural meaning, in my submission, modification simply means a change of the law as it applies to reserved matters. So for condition 1 to be satisfied, a bill must have firstly made a change to the law, that's whether statutory or common law, and that change must have an impact on the law, whether statutory or common law, as it applies to a reserved matter. For reasons I'll come on to develop later, my lady, the petitioners contend that the bill does not contain modification of the law as it applies to reserved matters. If your ladyship accepts that submission, she need go no further. The prerequisite for the exercise of the power under section 35(1)(b) is not met. One might say, to use a language familiar with convention rights, that section 35 is not engaged, whatever the effects of the bill. The order would thus be unlawful and fall to be reduced. But if contrary to that submission, and your ladyship thinks condition 1 is satisfied and is met, then it is necessary to consider condition 2, which is that the Secretary of State must have reasonable grounds to believe that the provisions would have an adverse effect on the operation of the law as it applies to reserved matters. I'll deal in more detail with what amounts to reasonable grounds to believe, and take issue with what seems to be the respondent's suggestion that it's all a matter for the Secretary of State's judgment, and that judgment in practical terms is not amenable to review. I've already touched on that point when looking at Cherry and what was said at paragraph 39. I say, my lady, that the Advocate General's approach is inconsistent with that taken to powers of executive veto in other contexts, where the threshold is reasonable grounds to believe, and where exercise of the veto would rub up against fundamental constitutional principles. As for adverse effect on the operation of the law, I'll deal later with the specific alleged adverse effects relied on by the Secretary of State. But at a general level, it is my submission that the effects must be sufficiently cogent to justifying exercising an executive veto over a bill passed by a democratically elected legislature within the limits of its legislative competence. I further submit that cogency falls to be considered within the overall constitutional scheme in which the UK Parliament has permitted divergence on this issue, and specific provision has been made to address anomalies which may arise as a consequence of devolved legislation. Such a provision is notably Section 104A, Section 104 of the Scotland Act, which enables the UK government to make provision by subordinate legislation, which is considered necessary or expedient in the consequence of any provision made by an Act of the Scottish Parliament. That provision has been invoked more than 100 times in the scheme of devolution, and the importance of 104 orders in that scheme has indeed been noticed by the courts, by Lord Roger of Aylesbury in the case of Martin against Most, and that's at page 267 of the reserve list, my lady. I'm sure my lady's familiar with that case. And I refer particularly to paragraphs 78 through to 90. So I'm going to unpack that a little. The first factor is the UK Parliament has permitted divergence on this issue. I've touched on this before. A legislative choice has been made to permit Scotland to diverge from the rest of the UK on the issue of gender recognition. Either the subject matter of gender recognition could have been reserved in Schedule 5 of the 2004 Act, or it could have been listed as a protected enactment under Schedule 4. Neither was done. The UK Parliament was content to permit Scotland to go its own way on the issue of gender recognition if the Scottish Parliament chose to do so. That legislative choice, a legislative choice by the UK Parliament, should not be thwarted by the executive. However, some of the reasons relied upon by the Secretary of the State are in effect objections to divergence per se. That is not legitimate. Secondly, the power of veto must be seen in the context of the UK Parliament having made specific provision to address anomalies. At paragraph 3...
You may be coming on to this order, but I just note you're saying that some objections by the respondents are you say are objections to divergence per se. Are you able to point us, or are you going to come to those in due course? Which particular objections you say are objections to divergence in and of itself?
I think I'll come on to that later.
Very well, thank you.
Explore it in detail.
Thank you.
And I'm going to make specific reference to the order when I come to do that. And later, I hope will see that I'm correct in that submission. Secondly, in relation to the power of veto, it has to be seen in the context of the Parliament making specific provision to address anomalies. And I referred to paragraph 3.2f of the Advocate General's note of argument and to his objections to my pointing to the availability of Section 104. The suggestion that a Section 104 order could not be considered in the 4-week period in which the Secretary of State was considering whether to make an order under Section 35 is entirely misleading. In early 2022, Scottish Government officials sought to instigate discussion about the terms of any Section 104 order. That is not an uncommon approach. Whilst a Section 104 order cannot be made until the bill's passed, work on preparing such an order often begins some time before. For reasons that I'll develop later, the petitioners contend that the Secretary of State could not, on the material before him, have been satisfied that there were reasonable grounds to consider that Condition 2 was satisfied. Once more, if that submission is accepted, your ladyship needs to go no further. The order is unlawful and falls to be reduced. If, on the contrary, your ladyship is satisfied Condition 2 is met, it's then necessary to consider Condition 3, which itself comprises 2 requirements imposed by Section 35(2) as to the content of any order. That is, the order must identify the bill and the provisions in question, and the reasons must be stated for making the order. So I accept that the order fulfills the formal requirement of identifying the bill and the provisions in question. As for reasons, where the legislature has imposed an obligation upon a decision maker to provide reasons for a discretionary decision, the common law has long required that those be of sufficient quality to discharge the statutory obligation. I doubt that authority is required for that proposition, but reference is made in the note of argument to Lord Reid's opinion in Chief Constable against Lothian and Borders Police at paragraph 70. I invite your ladyship to find that lawfully sufficient reasons are required as a condition precedent to making a lawful order under Section 35. And I don't expect there to be a serious dispute about that issue. As to whether the reasons provided in this case are lawfully sufficient, I will address the reasons in Schedule 2 of the order in the course of the last chapter of my submissions. My submission will be that they are insufficient in law to justify the making of the order. So, if contrary to my earlier submissions, your ladyship finds that Conditions 1 and 2 are satisfied, the order falls to reduced on the grounds that the reasons produced are insufficient in law. So dealing then with the bill, and this is at page 5 of my outline note, and paragraph 6 to 18 of the note of argument. I have, of course, addressed your ladyship on the constitutional context within which this case arises and the proper construction of 35, before turning to the grounds upon which the petitioners challenge the validity of the order. It is necessary for me to put the subject matter of the bill, gender recognition, in its legislative context. And this, I'm sure, is something the lady is very familiar with. And it starts by me looking at the Gender Recognition Act 2004. It was, of course, passed by the UK Parliament and provides for when a person may obtain a gender recognition certificate so far as material for present purposes. The 2004 Act currently applies throughout the United Kingdom. Under the 2004 Act, a gender recognition certificate can currently be obtained following on an application by a person who's aged at least 18 to a gender recognition panel, and that's contained in Section 1 of the 2004 Act. Leaving aside for the moment applications from people who've changed their gender abroad, an application must be granted if the panel is satisfied that the applicant has or has had gender dysphoria, has lived in the acquired gender in the 2-year period before making the application, intends to continue living in the acquired gender until death, and has provided required evidence, Section 2.1. The evidence includes a report by an appropriate clinician practicing in the field of gender dysphoria, giving details of the diagnosis of the applicant's gender dysphoria. That's Sections 2.1 to 2.2. The effect of acquiring a gender recognition certificate under the 2004 Act is prescribed by Section 9. That is worth turning up. It is at PDF 508, and it's also set out in Statement 15 of the petition. And Section 9 provides, it's at the top of page 6 also of my speaking note, my lady. Section 9 provides, where a full gender recognition certificate is issued to a person, the person's gender becomes for all purposes the acquired gender, so that if the acquired gender is the male gender, the person's sex becomes that of a man, and if the female gender is the female gender, the person's sex becomes that of a woman. Subsections 2 and 3 then make consequential provisions which are not relevant for present purposes. For the purposes of the 2004 Act, a full gender recognition certificate is defined in Section 25 of the 2004 Act. That's at PDF 256. And it means a gender recognition certificate issued under Sections 4, 5 or 5A of the 2004 Act. In the case for Women's Scotland Limited against Scottish ministers, which is at page 508 of the PDF, your ladyship held that Section 9 of the 2004 Act meant that those in possession of a full gender recognition certificate were, for the purposes of the Equality Act, the sex conferred by their certificate. In other words, sex for the purposes of the 2010 Act meant a person's sex recognised by the law and was not tethered by biological or birth sex. That is clear from your ladyship's decision. But there is some force in the point made by Stonewall in their submission at paragraph 44, that an underlying error which pervades the Secretary of State's reasoning for making this order is a view that sex for the purposes of the 2010 Act should mean biological sex. And that is wrong as a matter of law, which is clear from paragraph 53 of your ladyship's decision in paragraph 53. So the Gender Recognition Act is a gender recognition law, not an equality law. And of course, the Equality Act, is silent on gender recognition. And that is how the law stood at the time the bill was being developed. And it's how the law will remain in Scotland in the event the bill is not prevented from being law. I turn to the bill and start with the development of the legislative proposal now. And I know my lady will have been careful in looking at all the material that's relevant to this and the documents that have been produced. So I hope to be able to take my ladyship through this part of my submission quite quickly without delving into detailed documents. So the Scottish Government committed to reforming the 2004 Act as part of the Fairer Scotland Action Plan, which was adopted in 2016. It undertook 2 consultations. The first, which ran between November 2017 and March 2018, was on the principles of reform of the 2004 Act. The second, between December 2019 and March 2020, was on a draft bill. Analysis of the responses to each consultation have been published by the Scottish Government and have been produced as numbers 6.5 and 6.7 in the first inventory of productions for the petitioners. These are lengthy and I don't intend to turn them up. The UK Government did not engage with either consultation exercise and offered no comment on the proposals. In particular, there was no suggestion that the sort of changes being considered would cause insurmountable problems, for example, HMRC computer systems and software engineers responsible for their coding. While the UK Government did not engage with the Scottish Government's consultation, it launched its own public consultation. In 2018, July 2018, the UK Government launched its own public consultation, separate from the proposed reforms to the 2004 Act. So the Scottish Government adopt consultation exercises for the Scottish position, and the UK Government launched their own. And that UK Government consultation is produced as item 5 in the petitioner's marked up bundle. Again, it's lengthy and I don't intend to turn it up, but I'd like to make a few points about it. First is this: the consultation of the UK Government concerned only the law of England and Wales. That's referred to at paragraph 158 of that document. That clearly acknowledges that the devolved administrations could make different provision. It is also implicit that, as of July 2018, the UK Government did not consider that different regimes operating in different jurisdictions of the United Kingdom would lead to serious adverse effects. That goes against the grain of the Secretary of State's concerns set out in order, when what was evidently considered acceptable in July 2018 became unacceptable is not clear. What has changed is the UK Government's policy in this area. But as already advertised, my submission that policy differences are not a proper basis for a Section 35 order. The other point to note from the UK Government consultation is that it did initially indicate support for moving away from the requirement for a medical diagnosis before an application for a gender recognition certificate could be made, and stated that it was persuaded that the process should be made easier. That's in paragraph 26 of the consultation. No concerns are noted about an increase in fraudulent applications or the like. Again, when such concerns arose between July 2018 and making of the order, it is not clear. The Scottish Government, having considered international evidence, doesn't believe there to be such a risk. In September 2020, the UK Government published an independent analysis of its responses to its consultation. That analysis found that 64.1% of respondents said there should not be a requirement for a diagnosis of gender dysphoria in the future. However, in September 2020, following a change of Prime Minister, the UK Government announced it would not take forward the reforms to the requirements for gender recognition. Coming now to the passage of the bill. The passage of the bill received a high level of scrutiny. It was introduced in the Scottish Parliament by the Cabinet Secretary, Shona Robertson, MSP, on the 2nd of March 2022. Prior to its introduction, in accordance with normal practice, the bill and the accompanying documents were made available to the UK Government. That is, the UK Government saw the bill before the MSP saw it. The bill was accompanied by a policy memorandum, a financial memorandum, an equality impact assessment, and a delegated powers memorandum. The equality impact assessment is number 6 on the petitioner's bundle of marked up documents, beginning at page 251. That considered whether the bill impacted upon men and women in different ways, and whether it impacted on people because of their sexual orientation, and whether it impacted upon transgender people. The Equality Impact Assessment, Lady, is of course carried out in order to meet the public sector equality duty that's imposed by the Equality Act under section 149. So the bill was assessed as having no negative impact in respect of any of these groups. I mention that because the terms of the Equality Impact Assessment have not been challenged by the Advocate General. The Secretary of State has never criticised, either publicly or in official-to-official conversation, any aspect of the Equality Impact Assessment. And this will be relevant to the issues that have been suggested arise under the public sector equality duty that we'll come on to touch upon later. So the course of the bill was in line with established procedure, but it's worth saying a little about what that entailed to emphasise the high level of scrutiny. The Equalities, Human Rights and Civil Justice Committee was appointed the lead committee for the bill. It issued calls for views, which ended on the 16th of May 2022. After holding a number of evidence sessions, the lead committee published its Stage 1 report on the 6th of October 2022. That is produced as item 7 in our marked up bundle of documents. Your ladyship will have seen from the highlighted passages that the committee considered evidence from a wide range of people and looked at international comparisons to see the impact gender reform legislation was having internationally. On the 26th of October then 2022, the Scottish Government published its response to the lead committee's Stage 1 report. And on the 27th of October 2022, the Scottish Parliament debated in plenary session the general principles of the bill. These were approved, 88 votes for, 33 against, and 4 abstentions. The bill then proceeded to Stage 2. Consideration was concluded on the 22nd of November 2022. It was considered again by the Scottish Parliament in plenary session on the 20th and 21st of December 2022. A series of amendments were debated and voted on, and on the 22nd of December 2022, the bill, now in its final form, was debated at Stage 3 of the legislative process. It was passed by the Scottish Parliament by 86 votes to 39, with 4 abstentions. So what are the contents and the effect of the bill? The bill, as passed by the Scottish Parliament, is item 2 on the petitioner's marked up bundle starting at page 16. It's also produced as item 3, as item 3 is the Gender Recognition Act as prospectively amended by the bill, and that starts at page 52. I will give references to the 2004 Act as amended and as required, and work from that document. But what the bill does then is amend the circumstances in and the process by which a person may obtain a gender recognition certificate in Scotland. It provides for the Registrar General of Scotland to issue a gender recognition certificate, which would have effect in Scotland, but not without specific further provision recognising it in the rest of the UK. Section E of 80 of the 2004 Act as amended by the bill, and that's at page 72. I will refer to the gender recognition certificate issued under the bill as a Scottish gender recognition certificate or an SGRC, and when I speak of GRC, that is a certificate issued under the 2004 Act as it currently stands. The availability of the Scottish Gender Recognition Certificate does not preclude an application for a certificate under the 2004 Act, as it would continue to apply in the rest of the UK. A person who would be entitled and eligible to apply for a Scottish Gender Recognition Certificate would remain eligible to apply for a gender recognition certificate under the 2004 Act as it applied to the rest of the UK. And the principal changes made by the bill can be summarised as follows, and I've listed these in the outline note already. It lowers the minimum age at which an application can be made. That's from 18 to 16, and that's reflected in Section A of the 2004 Act as amended by the bill. It reduces the period in which a person requires to have lived in the required gender from 2 years to generally 3 months, and that's Section 8C of the 2004 Act as amended by the bill. And it removes the requirement that the applicant has a diagnosis of gender dysphoria. It treats a person who has changed gender under the law of a country or territory outside of the UK for all purposes as having a Scottish gender recognition certificate, unless it would be manifestly contrary to public policy to do so. And that's Section 8N of the 2004 Act as amended by the bill. So the effect of acquiring a Scottish gender recognition certificate under the bill would remain that prescribed by Section 9 of the 2004 Act. That section is unamended and untouched by the bill. Its effect in respect of a Scottish gender recognition certificate would be exactly the same as its effect in respect of a gender recognition certificate. However, a Scottish gender recognition certificate issued under the bill would not be the same as a gender recognition certificate issued under the 2004 Act, as it would continue to apply elsewhere in the UK. So unless recognised elsewhere in the UK, the Scottish certificate would be of no effect elsewhere in the UK. That, in a nutshell, is what the bill does, or would do if it were to receive royal assent and then be brought into force.
And that, I suppose, Lord Advocate, is one, perhaps not the only, but it's one of the key points of difference between you and the Advocate General. Because, of course, as you understand, the Advocate General says, well, it may not change the words in Section 9, but what it does do is change the effect of those words so far as the changing the cohort or the numbers and so on of people who could benefit from the provisions of Section 9. But your answer to that is that it is not a modification because there has been no attempt to change the language and the
impact of the effect of Section 9.
You may be coming on to this, but how do you respond to the point that it's argued that it does have an effect because the cohort of people, and to try and pick a sort of generic phrase, but the cohort of people who might obtain a Scottish gender recognition certificate is meaningfully different from the cohort that could obtain one under the 2004 Act.
Yeah. So I think it's important to recognise what the bill does not do, my lady.
I'm sorry, I didn't quite...
It's important to recognise what the bill does not do.
Yes.
Just to answer this part of the point my lady's raised. Whilst it would be within the legislative competence for the Scottish Parliament to amend Section 9, the bill doesn't do that. And accordingly, and this I hope answers the point, the consequences of obtaining the certificate, the Scottish certificate under the bill, would be identical to the consequences of obtaining a gender recognition certificate under the 2004 Act as it currently stands. Yes, the respondent is correct when he says that the 2010 Act interacts with the 2004 Act because of the effect Section 9 of the Act gives to a gender recognition certificate and would give to a Scottish gender recognition certificate. But Section 9 is the interface between the two Acts, and it is untouched by the bill. And Section 9 is not the only interface between the 2004 Act and the 2010 Act. It's the interface between the 2004 Act and the law, the statutory and common law more generally. It is Section 9 which gives its practical effect and meaning to the acquisition of a gender recognition certificate, and it would do the same to a Scottish gender recognition certificate. And the effect and meaning would in Scots law remain the same as that currently given to a gender recognition certificate. I think that part of the Advocate General's discussion,
which is to change a person's sex for all purposes, subject to subsections 2 and 3 that we're not looking at for today's purposes.
So I think that there certainly is part of the Advocate General's argument that an increase in numbers is a problem, but that's not an answer for him to the import of the Scottish Bill. The Bill doesn't amend the Act in terms of Section 9. The consequences under the Bill in terms of obtaining a certificate under Scottish gender recognition procedures and under the current gender recognition procedures would be identical, and it would have the same consequences under the Act as it currently stands.
Is that maybe that? So I can certainly understand what you're saying, that the consequences would be identical, certainly for the individual who obtains a certificate. In other words, they would then be able to say, my sex is the sex on the certificate now for all purposes. So, and that's whether that's under the 2004 Act or whether it would be under the prospective Scottish legislation. Just testing the argument, maybe that Mr. Johnson will put this a different way, but the respondent might say, I suppose, that the consequences viewed objectively are different. Subjectively, for each individual who obtains a certificate, the consequences are the same, whichever route one follows. But objectively, they are different in terms of potential impact, obviously argued to be impact on reserved matters, but the impact more widely. But you say that's not a concern. It shouldn't be a concern.
I'm looking at condition 1,
mm-hmm.
and I'm saying that condition 1 of the order is not met because there's not been a modification of the law as let me just see the test. It's not. It doesn't fall within the first condition, which is that the provision would have had an adverse effect on the operation of the law as it applies to reserved matters. Because, I'm so sorry, condition 1 is it contains a provision which makes modifications of the law. I say there's no modification of the law as it applies to reserved matters, and that's the end of the issue insofar as my lady's concerned, if I'm right on my arguments in terms of Section 1. I'll come on to deal with the Advocate General's position in relation to what might be perceived as a problem, because more people might get a gender recognition certificate and more people might be persuaded, because of the removal of gender dysphoria as a medical diagnosis, to apply for a certificate. But it's really not appropriate, in my submission, for the Secretary of State to approach this matter on the basis of an increase in numbers and that developing into some significant adverse effect on the operation of the law. I'm going to come on to deal with that in detail later on, my lady, but my point at the moment simply is there's no amendment to Section 9. The consequences for a Scottish certificate are identical to that of obtaining a gender recognition certificate as it currently stands, and the effect that Section 9 gives to a gender recognition certificate and a Scottish gender recognition certificate is untouched by the bill. So it's not making a modification on the law. So having placed Section 35 of the Act, Scotland Act, in its constitutional context and the bill in its legislative context, I turn then to consider the grounds on which the petitioners contend that the order is unlawful and falls to be reduced. As your ladyship will have seen from the note of argument, these grounds are grouped under 4 headings: error of law, irrationality, irrelevant considerations, and reasons. And while there is to some degree an overlap between these categories, I now propose to address each of these in turn. And error of law is directed at what I've referred to as Condition 1. And your ladyship will recall that that requires a bill to make a change to the law, whether statutory or common law, and that change would have an impact on the law, whether statutory or common law, as it applies to reserved matters. In being satisfied Condition 1 was fulfilled, it is my submission the Secretary of State materially erred in law and so vitiated his decision to make the order. Before explaining why that is so, it is necessary to say a little bit about the case law on error of law. I begin with a proposition that might be thought trite. A person exercising a discretion conferred on them by statute must properly understand the law that governs the exercise of that decision. Lest authority be required for it, I make reference in the note of argument to Lord Diplock's famous speech in Council of Civil Service Unions against Minister for the Civil Service, which is at PDF 327 in the reserve bundle and referred to on page 7 of my outline note. He said, "The decision maker must understand correctly the law that regulates his decision-making power and must give effect to it. Whether he has or has not is par excellence a justiciable question to be decided. In the event of dispute by those persons, the judges by whom the judicial powers of the state is exercisable." So Condition 1 raises precisely the sort of question which Lord Diplock describes as par excellence a justiciable issue. At various points, the Advocate General asserts that whether to make an order under Section 35 is all a matter for the judgment of the Secretary of State and is not an assessment which should be reviewed by the court, or at least not with any degree of intensity. As I have already made clear, I don't agree with that. But that line of argument is only once engaged once Condition 1 is satisfied. Condition 1 concerns an issue of law, and Condition 1 was whether that's satisfied really is a matter for you, my lady, to reach a view on. And if you come to the view that the Secretary of State did err in respect of Condition 1 in order to vitiate a decision, the error of law must be material. It is material if it was an error in the actual making of the decision which affected the decision itself. An error of law affects the decision unless it can be said the decision maker would have inevitably reached the same decision on a correct understanding of the law. I doubt that these propositions are controversial, and the authority is cited for these in the note of argument. And I don't think we need to turn up these authorities. The first is R against Hull University Visitor, ex parte Page, 1993. And the other one is Sadvoska against the Secretary of State for the Home Department, 2008, Scottish cases, UK Supreme Court, session cases, UK Supreme Court at 38. And I refer there to Baroness Hale at paragraph 33. So applying these principles to the case before the court, I say the Secretary of State has made two errors of law, each of which are material in the sense that I've just explained. The first is a sharp and fundamental error. Nothing in the bill makes modifications of the law as it applies to reserved matters, nor does it have an adverse effect on the operation of the law as it applies to reserved matters. The operation of the law, I submit, refers to the mechanics of the law, how the law works, rather than the policy behind it. I note that the same point is made by Stonewall in their intervention at paragraph 27. As I've already explained, the interface between the bill and the wider law, in particular the 2010 Act, which is the principal focus of the Secretary of State's reasons, is Section 9 of the 2004 Act. As we've seen, nothing in the bill changes how that provision would operate. It's unamended by the bill, in form and in practice. The operation of Section 9 does not differentiate between a Scottish and a gender recognition certificate. The same consequences flow from each. If that's correct, the Secretary of State has not properly understood the law relevant to this decision made, for he proceeds on the assumption that different consequences flow from holding a Scottish rather than a gender recognition certificate. In my submission, he's just wrong about that. As I said, exactly the same consequences flow from the Scottish and the gender recognition certificate, and so there's no change that has an impact on reserved matters. If that's correct, the Secretary of State's misunderstanding of the law was material to the making of the order, and reduction of the order should follow. The respondent does accept, as he's bound to do, that Section 9 is unchanged, in the sense that the bill doesn't amend its text. And as my lady's pointed out, he argues that it's in substance amended. That's his point. He relies on certain observations made by the Supreme Court in the Continuity Bill case, which is UK withdrawal from the European Union Legal Continuity Scotland Bill case 2019 Supreme Court, and I make reference to paragraph 51 of that decision. And I've quoted from that in my speaking note to assist with access to the authority, my lady. Both in his answers and in his note of argument, the respondent quotes individual phrases from this passage. In order to establish any relevance it may have to the matters before the court, it's essential that the paragraph is looked at a whole. And it's essential to remember that this case was concerned with the competence, legislative competence of a bill, as opposed to the situation that we're in this case. So at page 544 of the PDF, the paragraph 51 reads as follows. As appears from the authorities cited by the Lord Advocate, one enactment does not modify another merely because it makes additional provision in the same field of law. If it did, the important distinction between the protection of enactments from modification under Schedule 4 to the Scotland Act and the inability of the Scottish Parliament to legislate in relation to reserved matters under Schedule 5 would become obscured. When the UK Parliament decides to reserve an entire area of the law itself, it does so by listing the relevant subject matter in Schedule 5. When it's not taken that step, but has protected a particular enactment from modification by including it in Schedule 4, it is not to be treated as if it had listed the subject matter of the enactment in Schedule 5. Where the only relevant restriction on the legislative power of the Scottish Parliament is the protection of an enactment from modification under Schedule 4, the Parliament has the power to enact legislation relating to the same subject matter as the protected enactment, provided it does not modify it. Without attempting an exhaustive definition, a protected enactment will be modified by a later enactment, even in the absence of express amendment or repeal, if it is implicitly amended, disapplied, or repealed in whole or in part. That will be the position if the later enactment alters a rule laid down in the protected enactment or is otherwise in conflict with its unqualified continuation in force as before, so that the protected enactment has to be understood as having been in substance amended, superseded, disapplied, or repealed by the later one. So a modification arises if it alters a rule or it's in conflict with the continuation in force of legislation as it was before. So placed in its proper context, the Advocate General really has been selective in this, the passages he's looked at from this part of Continuity Bill case. It simply cannot be said that the bill alters the rule laid down in Section 9 of the 2004 Act. It leaves it untouched in form and in substance, nor is the bill in conflict with unqualified continuation in force of Section 9. It is simply applied in its existing form to the Scottish Gender Recognition Certificate within Scotland, as well as gender recognition certificates. It cannot, in my submission, be said to have been modified in the sense explained by the Supreme Court in paragraph 51. And your ladyship will appreciate, as I said, that the context of this discussion...
I'm sorry to interrupt, Lord.
Yeah.
Just since you raised the point, if I don't mention it now, I'll forget later. So, I mean, the word conflict, of course, is a slightly emotive aspect to it, but the phrase is in conflict with the unqualified continuation in force as before.
Right.
I suppose it might be said that, whether one chooses the word conflict or another descriptor, Section 9 is not continuing an is not going to be an unqualified continuation in force as before, for the very obvious reason that the purpose of this bill is to change the procedure, the process by which a gender recognition certificate can be obtained, and put very short, to make it simpler and more liberal in the general sense. So is it not fair to say that that means that Section 9, by deliberate design, will not continue in unqualified continuation in force as before, because that's what lies at the very heart of this legislation, is the intention that it should be different. It should allow more and different people to apply.
The provision of Section 9, my lady, is the provision that applies to give effect to the gender recognition certificate in order that an individual assumes the required gender and changes their legal sex in law. And that provision has not been changed at all. So.
I don't disagree with you. Clearly, the language is exactly the same. I suppose I'm just trying to understand properly what how one analyses that, because you're right. Obviously, the language has not been changed, but is that effectively is it your position that matters just begin and end there? That
Section 9 explains effect. That will be the same, and your ladyship will appreciate that the context is discussion of the prohibition of modification of protected enactments and Schedule 4 of the Scotland Act. What the respondent contends is that...
So just to be clear, you're obviously quite right, Lord Advocate, this is in a particular context, this case. And as you rightly remind me when you started, we need to remember the context of that case. But do you, just so I'm clear, do you say that the proposition at the end of the quote that you've just read out applies only in the context of protected enactments, or can it can apply more widely?
I can see that it would be a reasonable source for thinking to look to see whether or not you can get guidance on whether there's been a modification. But the import of it is, what it actually says is in substance amended, superseded, disapplied or repealed by the later one. And my point is Section 9 remains the same. It explains the effect of a certificate, and that will be the same whether you have a gender recognition certificate under the 2004 Act or the Scottish Gender Recognition Certificate. So just to put my position clearly, lady, the Advocate General contends that Section 9C of the bill, of the schedule to the bill, amends Section 9 in substance because it changes the meaning of the phrase Gender Recognition Certificate by its express amendment of the definition in Section 25 of the 2004 Act. Full gender recognition certificate will thus mean something different in Section 9 if the bill becomes an act. But I say that takes the Advocate General nowhere. If the bill comes into force in Scotland, Section 9 will apply to the Scottish Gender Recognition Certificate, whereas in the rest of the UK, it will only apply to a gender recognition certificate. But the effect it will give to the respective certificates within the respective jurisdictions is identical. I hope I made my position clear on that, Lady.
Yes. Yes, thank you.
Turning now to the second area of law, and that relates to the Secretary of State's reliance upon the alleged effects of the bill on the operation of Social Security and HMRC systems. Schedule 2 to the order begins by asserting at paragraph 1 that the provisions of the bill make modifications to the Gender Recognition Act as it applies to the reserved matter of social security schemes. And the only elaboration in Schedule 2 itself is in paragraph 8, where it says this: the creation of a dual system has serious adverse practical consequences on the operation of the law as it applies to the administration of tax, benefits and state pensions which are managed by integrated systems across the UK. I would ask your ladyship to note at this point what is said at the start of that sentence: the creation of a dual system has. I'll return to this later in the context of relevant considerations, but I'll signpost the point now. It is plain from the language used that this is an objection to divergence simpliciter, and not, as now suggested by the Advocate General, this particular form of divergence. In Schedule 2, the Secretary of State has relied upon the creation of a dual system, not this particular system, the creation of a, in other words, any dual system. But returning now to the error of law complaint, the effects on the operation of the law are entirely unspecified. I understand that there are no gender-specific provisions in UK tax code, and by UK tax code I mean taxes imposed on a UK-wide basis by the UK Parliament. Separately, I understand that HMRC systems already accommodate differences in the law of different jurisdictions of the United Kingdom. It is hard to understand why the change which the bill would introduce, which would allow a person to have a legal sex in Scotland, which may be different to other parts of the UK, would present a difficulty. It is also difficult to conceive of a situation where a person would simultaneously be one legal sex in Scotland and a different legal sex, say, in England and Wales, for the purposes of a particular tax. Rather, in any given case, either the law of Scotland or the law of England and Wales will apply so as to determine the person's sex for the purposes of that particular tax or benefit. So my complaint about the concerns being unspecified is not an abstract or academic complaint. It is instead very challenging to understand what the substance of the Secretary of State's concern is. And I'll return to this when considering the reasons. It was for the Secretary of State to explain his reasons, not for the Scottish ministers or others or any informed person to try and work out what he was on about. So if it's permissible to look at what's said in the policy statement of reasons, the reader can be scarcely any the wiser. At paragraph 20 of the policy statement of reasons, we'll just get, does my lady have that? Paragraph 20, where's that in PDF? I'll just maybe get the PDF number, it probably, it's in the marked up bundle, my lady, I'll just get it. It's quite early in the marked up bundle. So it's just looking at the schedule that was presented by the Secretary of State.
I've got a hard copy.
Oh, yeah. I think that's quite helpful to look at it.
So I think you were at paragraph 20
of the Statement of Reasons, not the annex to the schedule that was lodged in Parliament.
Yes, not the actual policy statement.
Yeah.
Yes.
So it said at paragraph 20, existing IT infrastructure only allows one legal sex on any record, and cannot change the marker for 16 to 17-year-olds, those responsible for these systems may consider that it may be unmanageable, even with considerable time and expense, to build a system capability to manage a dual identity for the same individual if someone's legal sex could be different in Scots law and the law for England and Wales. As I say, I do not understand that proposition, given that the HMRC systems already accommodate different law in different jurisdictions of the UK. But your ladyship will have noted, which is significant, what is said in the policy statement of reasons to be may be a problem, to be morphed into something that has serious adverse practical consequences. When and why that transformation took place is not explained. So it was observed, I say, in the note of argument that it was surprising that at no point during the development or passage of the bill, which stretched over a number of years, were any of these concerns raised by the UK government. More particularly, as we've seen, the UK government consulted themselves on their own changes to England and Wales in relation to the 2004 Act. The creation of a dual system was plainly acceptable at that point. And so, having founded upon this reason, it is incumbent on the Secretary of State to explain, firstly, why a dual system, countenanced as it so recently was by the UK government, presents such a fundamental problem to justify executive veto of an otherwise legitimate legislative act, and secondly, why what were considered uncertain and speculative concerns, what may happen by the policy hub, become certain, serious, adverse practical consequences by the time the Secretary of State made the order. Separately, but no less importantly, no explanation is given of how the concerns expressed relate to the adverse effects of the operation of the law as distinct from concerns about the operation of IT systems. At paragraph 5.5 of his note of argument, under reference to the case of Hinchy against Secretary of State for Working Pensions, the Advocate General asserted that an adverse effect on the operation of the law can encompass matters of practical administration. The case doesn't support that proposition. Hinchy, which is a decision of the House of Lords, is the only authority cited in support of that proposition, but is not a proposition that can be properly taken from that case. The issue was whether the claimant had failed to disclose a material fact to the Secretary of State, and which was relevant to the calculation of her entitlement to benefits. See, for example, paragraph 49, page 576, where Lady Hale's formulation of the issues in the case are helpful, and she was concurring with Lord Hoffman's leading speech. Lord Scott dissented, but his reasons for doing so are not relevant. It is Lord Hoffman's speech that the Advocate General founds on at paragraphs 14, 21 and 28. Each of these paragraphs are narrative of earlier stages in the case and contain no statements of legal principle by Lord Hoffman. Indeed, there is nothing in the speech which supports the proposition the Advocate General seeks to take from the case. In my submission, an effect, and if we take the policy statement of reasons as a possible effect, an IT system is not an effect on the operation of the law. The law operates in the same way, irrespective of whether software engineers responsible for writing, the coding for HMRC systems can give effect to it or not. The Advocate General's assertion to the contrary is simply that, an assertion. It's not supported in authority, and I submit to my lady that she should reject it. If that is wrong, and your ladyship is prepared to accept that such concerns about a possible impact on IT systems are capable, in principle, of amounting to an adverse effect on the operation of the law, only a cogent explanation of the nature and magnitude of the difficulties could justify the use of an executive veto of a bill within legislative competence. It is ultimately an issue of coding software, and it is, to put mildly, surprising that in this day and age it's being said on behalf of the UK government that this bill presents an insurmountable challenge to their software engineers. There is no indication that an explanation of the difficulties has been provided to the Secretary of State, far less petitioners, and speculative concerns, and the policy statement of reasons indicate that these are speculative concerns, are of unidentified officials about the ability of IT experts to make appropriate technical changes, and these, in my submission, are insufficiently cogent to support the decision to make the order. They simply do not satisfy condition 1, and if that condition is not satisfied, the order cannot be made. And by proceeding upon the basis of this reason, I say the Secretary of State erred in law. That error in my submission is material, and so vitiates the order. And then finally, under the heading of error of law, I should deal with an ESTO argument advanced by the petitioners in Statement 35A of the petition. The Secretary of State's analysis and almost all of his concerns about the bill is underpinned by the assumption that the meaning and effect of Section 9 of the Gender Recognition Act was correctly explained by your ladyship in For Women Scotland, and the petitioners agree with that. However, if your ladyship's explanation of the meaning and effect of Section 9 were not supported by the appellate courts, then it would inexorably follow that the Secretary of State's decision to make the order has proceeded on an incorrect understanding of the law. As to whether such an understanding was material to the decision to make the order, I have addressed your ladyship on the relevant test. A misunderstanding is material if it was an error in the actual making of the decision, which affects the decision itself, and an error of law affects the decision unless it can be said that the decision maker would have inevitably reached the same decision on a correct understanding of the law. So my lady will no doubt understand that given the interface between Section 9 of the Gender Recognition Bill and the way that it permeates order made by the Secretary of State, I say it cannot reasonably be suggested that the Secretary of State would have inevitably decided to make the order if his understanding of the law turns out to be erroneous. And on this ESTO argument, the order would fall to be reduced. So this has been explored, I think, in an earlier hearing, but I think just to make 2 points about it, my lady, before I move on to irrationality. The first is this: when this case called before your ladyship to discuss whether to proceed with this hearing, it was suggested on behalf of the Advocate General that having proceeded on the basis of your ladyship's decision would not have been an error of law because that was a reasonable understanding of the law at the time. I don't know if that line of argument is going to be insisted upon, and it's not pled in answer to Statement 35A of the petition, I say for good reasons. First, error of law is not a question as to whether a decision proceeded on a reasonable understanding of the law. It is a question as to whether a decision maker proceeded on a correct understanding of the law. It is no answer to an error of law challenge to say, okay, I may be wrong, but I made a reasonable mistake. Secondly, I presume that this will not be controversial. If the Inner House overturns a first instance decision, they do not change the law. They correct an error. They explain what the law has always been. So just as the Inner House would be saying, your ladyship erred in understanding of Section 9, and again, I say your ladyship was quite correct in her approach to Section 9, and the Scottish ministers are resisting that appeal.
Strenuously.
Yeah, they are. It's not clear that this line of argument, which was advanced when the case called on the 4th of August, but which was not pled in answer to Statement 35A and is not advanced in note of argument, is still to be insisted upon. So that's the approach to error of law. The second point is It may be said that the courts operate on the basis of the law as it stands and are not in the habit of entertaining hypothetical arguments. That is true as far as it goes, but the practical considerations in favour of considering the ESTO argument are, in my respectful submission, compelling. The issues in the two cases are closely connected. Possibility of a change, or more accurately, a confirmation that the law was not as it had been previously understood, is no mere hypothetical possibility. A reclaiming motion is about to be heard. If that reclaiming motion were to succeed, it's difficult to imagine that this case would not have to be re-argued, quite possibly whilst it was at abscondum. And the point is quite a short one. So I wonder whether my learned friend would seriously contend that the order could withstand scrutiny on the hypothesis that For Women Scotland was wrongly decided. That is certainly an impression left by the non-engagement with the issue in both answers and note of argument.
I suppose the only difficulty of why that troubles me, that Lord Advocate, I should just say now, is that, as I understand it, there are a number of grounds. I'm obviously not privy to the in-depth detail of it, but as I understand it, there are a number of grounds of appeal in For Women Scotland, and I suppose it's conceivable that one of them might succeed, two might, all five, as I think it might be about five, all five might succeed. But as we stand here today, we don't know whether any will be successful, which, if any, will be successful, and whether, even if successful, perhaps only on one ground, let's say, that is of any direct relevance. As I say, I don't have any understanding of the detail of what these arguments are, but it may be that it succeeds on a let's call it a peripheral argument, which isn't material to. So I hesitate to go along with the whole of the contention that you make, that it is inevitable, in effect, that if For Women Scotland is successful in the inner house, then that has the consequence, because we simply don't know if successful, what that success will look like, I suppose. So I just wanted to flag that up at this stage in fairness, that I have some hesitation in adopting in its entirety the contention that you make, but don't let me take you off your.
So you can come back. So in relation then to the next part of my argument that relates to irrationality, this ground of challenge is directed at condition 2, which your ladyship will recall is that the Secretary of State must have formed a reasonable view, that is a rational view, that the provision in question would have an adverse effect on the operation of law as it applies to reserved matters. In my submission, the Secretary of State's decision cannot be said to be reasonable or rational. It is therefore unlawful and should be reduced. So before developing my submissions and reasons in this ground, I should address the Court on the appropriate test or standard to apply. In his note of argument at paragraph 4.2, the Advocate General contends that the issue is whether the decision was so outrageous in its defiance of logic or accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it. So those words are taken from Lord Didcot famous speech in Council of Civil Service Unions against Westminster for the Civil Service, 1985 appeal cases, PDF number 327 in the reserve bundle, and the quote is from page 410 of the report. As your ladyship will be aware, the courts have expressed the test in less hyperbolic terms, increasingly so in recent times. References to leading cases are contained in the petitioner's note of argument to vouch the possibility that irrationality is not a fixed standard, that the intensity of review is variable. It is context dependent. What is required will vary depending upon the circumstances of the case. So rather than turning up a series of cases from the bundle, it may be more convenient to refer your ladyship to the note of argument. If she has that before her at page 13, she will see reference at paragraph 36 to the case of R against Secretary of State for the Home Department, ex parte Boudica, 1987 appeal cases, page 514 at 531. Here he said that the court must be entitled to subject an administrative decision to a more rigorous examination to ensure that it is in no way flawed according to the gravity of the issue which the decision determines. In a similar vein, Lord Phillips in RQ against the Secretary of State for the Home Department in 2004, Queen's Bench at 36 at paragraph 112, stated this: the common law of judicial review in England and Wales has not stood still in recent years. The courts have developed an issue-sensitive scale of intervention to enable them to perform their constitutional function in an increasingly complex polity. They continue to abstain from merits review, but in appropriate classes of case, they will today look very closely at the process by which facts have been ascertained and at the logic of the inferences drawn from them. Reference is next made to Lord Mance's judgment in Kennedy. The full name and case and the citation are missing. It's Kennedy against Charity Commission, 2015, appeal cases 455. And at paragraph 51, Lord Mance said that the common law no longer insists on the uniform application of the rigid test of irrationality, once thought applicable under the so-called Wednesbury principle. At paragraph 54, he added that the intensity of the review is heavily dependent on context. So the variable approach to intensity of review set out in Kennedy has been approved by the Supreme Court in the case of Pham against Secretary of State for the Home Department, 2015, One Leakley Robert Reports 1591, at paragraph 60, Lord Carnwath, and at paragraph 109, Lord Sumption. And then the last in the series of cases referred to at this point on the matter of the standard of intention of review for irrationality is the case of AXA against General Insurance Company against Lord Advocate. And what Lord Reid said at paragraph 142. There he said, the courts have the responsibility of ensuring that the public authority in question does not misuse its powers or exceed its limits. The extent of the court's responsibility in relation to a particular exercise of power by a public authority necessarily depends upon the particular circumstances, including the nature of the public authority in question, the type of power being exercised, the process by which it is exercised, and the extent to which the powers of the authority have limits or purposes which the courts can identify and adjudicate upon. So in his note of argument at paragraph 4.3, the Advocate General found some 4 factors to support the assertion that the Secretary of State's judgment in this matter should be afforded particular respect. The first is that the Secretary of State has particular expertise in this sphere, including having had the benefit of expert advice from the Equality Hub. It is not clear to which sphere reference is being made. If it is to gender recognition and equality, it is entirely unclear on what basis this particular expertise is claimed. I will come in due course to look at the advice provided by the Equality Hub. At this stage, I think, though, it's sufficient to say in my submission, the court should not afford any particular deference to the fact of advice from the Equality Hub, which is in effect a unit within the Cabinet Office, in the abstract. In substance, your ladyship is being asked to defer to essentially internal advice that one part of the government has given to another because the latter has chosen to publish and publicly rely on that advice. That, in my submission, is not appropriate. The court can and should consider that advice in the context of other material which was available to the Secretary of State and was, it seems, obviously not considered by him. So that's the first point.
I'm sorry, since you mentioned it, Lord Advocate, what do you understand the status of the, maybe you don't know the answer to this, and just please do say if you don't, Mr. Johnson might be able to help me, but what do you understand the status of the Equality Hub to be? You see it as a collection of internal advisors, is that what you understand it? As I say, I don't want to ask a...
Yeah. So we didn't know, and we asked, and we understand it's a unit in the Cabinet Office. So it is internal advice from unidentified persons.
The unit that, is it fair, or am I going too far to say claims particular expertise in equality matters because that's how they effectively badge themselves, I suppose?
Well, it might be Mr.
Might be
Johnson
better
can
to,
explain the badge.
all right, thank you.
But for my part, it's internal advice that one part of the government has given to another, and it's not appropriate for my ladyship to take any cognizance of in terms of expertise. So the Advocate General next says this about his judgment. It was evaluative. He says, my judgment, the Secretary of State's judgment is evaluative, predictive, and not susceptible to objective assessment. While there may be evaluative and predictive aspects to the decision, the blanket assertion that it's not susceptible to objective assessment goes far too far. We've already looked at what the Supreme Court said in Cherry at paragraph 39. A good deal of evidence, including evidence from the experience of other jurisdictions which have introduced systems based on self-identification, was considered in the course of the bill's passage through the Scottish Parliament. And some of the reasons relied upon by the Secretary of State are susceptible to objective assessment. That must be so, for example, in relation to alleged problems of the IT systems. Much the same may be said of the assertion he makes that the assessment is of the nature of adverse effects, and whether they justify making an order involves political judgment. Political judgment may come into the equation, at least in relation to some of the reasons relied on, but it must be exercised against a background of proper consideration of the available evidence. It is difficult to see that political judgment has much of a role to play in relation to such matters as the alleged problems in relation to IT systems. Finally, the respondent mentions that the order is subject to annulment in pursuance of a resolution of either House of the UK Parliament, in which the people of Scotland and the rest of the UK are democratically represented. In relation to this final point, two points do require to be noticed. Parliamentary approval is not conclusive evidence of lawfulness, and it cannot render what is unreasonable reasonable. That proposition is vouched clearly in the note of argument by reference to R. Javed against the Secretary of State for Home Department. It's on the reserve list of authorities, my lady, and I'm looking at paragraph 37 in that case at page 466 of the PDF. So, accepting the respondent's averments in answer 12 about the timing of the publication of the order, it cannot be said that Parliament has in fact considered and reviewed the order. That being so, the court should not be deterred from reviewing the reasonableness of the decision to make the order. The respondent says at paragraph 4.3d that if the petitioners mean to criticise the procedure by which Parliament carried out its function, that is not the criticism which the separation of powers permits the court to entertain. But, my lady, the petitioners do not mean to criticise the procedure by which the Parliament carried out its function. They merely draw your attention to the fact, the undisputed fact, that one, at the time the Secretary of State informed the House of Commons of his decision to make the order, his decisions had not been published, and secondly, the resolution seeking annulment of the order was tabled in accordance with parliamentary procedure, but time was not afforded to debate it and vote on it. So the order was sought to be annulled, but the House of Commons didn't give parliamentary time to the debate and to the vote.
So all you seek to take from that is that my hands are not tied, and it's not, because I think this is obviously, it strikes me this has caused some disquiet given some of the correspondence that's been lodged and so on. But just to be clear, your position is you make no criticism in the sense of impeaching procedure in Parliament, or you don't seek to take anything from that. It's merely that as a matter of fact, given the historic record of events, the matter is now open to the court to intervene and exercise its supervisory jurisdiction.
Exactly so. So for completeness in this part, lady, I should mention the case R. Evans against Attorney General, which is a case from 2015, Appeal Cases 1787. It's at PDF page 747. And this case is significant and highly relevant to the approach that should be taken in this case. So our evidence concerned the release, pursuant to a Freedom of Information request, of correspondence between the Prince of Wales and the UK government. My lady might remember it's the Spider handwriting case.
Yes, yes. The then Prince of Wales had been engaging in correspondence with various members or parliamentary figures, if we can put it that way. And as I understand it, the question was whether or not that was susceptible to any form of privilege or immunity, and whether it could be. I think journalists were interested in
Yes.
publishing it, as I remember.
Yes.
And there was a question whether it was preparation for kingship material and so on.
Yes. Well, my lady's very familiar with it. So the case concerned also, though, the release pursuant to a Freedom of Information request of correspondence between the Prince of Wales and UK government. The release had been ordered, but the Attorney General sought to override that decision using a veto power conferred by the UK Parliament. The provision was section 53.2 of the Freedom of Information Act 2000, and the detail of it is set out in paragraph 17 of Lord Newberger's judgment, which is to be found at PDF page 770. The clash was between a judicial decision and an act of the executive.
Yes, I just wonder, is that significant? I suspect you'll tell me it isn't a significant distinction for your purposes, but the heart of the discussion, if I understand it correctly, in evidence was the question that or whether it was an appropriate use of the veto in section 53 in effect to override a decision of the courts, was how it was. I use that language fairly loosely, but as a descriptor, the criticism was that the Attorney General had effectively sought to veto a legitimate judicial decision from the tribunal, and that was the context in which the discussion arose. Here, are we dealing with something slightly different in the sense that this is the exercise of a statutory of a statutory power, and the question is whether or not it's been exercised rationally or irrationally or otherwise. So I wonder, you say nevertheless, so what the dicta and evidence does have some import here.
So I think, yes, it's different in the respect that my lady points out, but it's still highly significant in relation to the constitutional principles of separation of powers and the way in which an executive veto on legislation enacted by the Scottish Parliament, a democratically elected Parliament, within its legislative power, should be looked at. What is this? How do you look at the executive veto? How has it been applied in a case where we're concerned with authority of the highest legal standing, which is a bill passed by the Scottish Parliament? So I think it's, when I come on to look at it in this detail, I hope my lady will see why I say it is important. Yes, it was a clash between a judicial decision and an exact act of the executive. Here it's between a legislative act and an act of the executive. Both engage separation of powers. As explained by Stonewall at paragraphs 20 to 24, and I should say I don't take issue with what was said by Stonewall in respect of Evans. I think the way that Stonewall explored the case of Evans and the propositions they've developed from that are sound and well framed. But faced with near identical statutory language, the UK government advanced near identical arguments to those which are being advanced here. So those arguments were rejected by the Supreme Court. So I've included Evans in the bundle as an example of the court being very exacting in its review of an executive decision. The discretion to make the decision having been conferred by the UK Parliament, when the effect of the decision was to rub up against constitutional principle, in particular, separation of powers. And the approach really is captured at paragraph 58 in Lord Neuberger's judgment, that if Section 35 was intended to allow the Secretary of State to cut across the plenary legislative powers conferred on the Scottish Parliament, subject only to a Wednesday rationality check, then crystal clear language would have been used, and the language of reasonable belief falls short. The approach contended for here by the Advocate General seeks a similar deference as was contended for in Evans. And no doubt Mr. Johnson will explore that with you. But in my submission, the court shouldn't defer to the executive in the manner that is to be suggested. And can I just show my lady how Stonewall approached this in their intervention at paragraphs 20 to 24. So, at page 7, heading is Supreme Court's approach to comparable provisions. That's on page 7, paragraph 18 and 90. Look at the case and the section that was considered under the Freedom of Information Act, which was very similar to the Section 35 power. And then over the page, at paragraph 20, Stonewall's intervention says, Evans concerned a request for information contained in communications between the then Prince Charles and various members of the government. The relevant ministers refused disclosure. The matter reached the upper tribunal, which ordered disclosure of some information. The Attorney General vetoed the upper tribunal's decision, exercising the Section 53(2) power, and Mr. Evans sought judicial review. The Attorney General in Evans adopted the same approach as the Advocate General adopts in the instant matter. He argued, Parliament had given the Attorney General a final veto over the disclosure of information in the form of Section 53(2). The words reasonable grounds bore their ordinary meaning. They didn't imply a higher test. And the question of legality did not therefore arise. Essentially, the proper standard of review was rationality. Goes on to say this, the Supreme Court rejected the Attorney General's approach. Neuberger, with whom Kerr and Reid agreed, concluded, 1. The principle of legality means that Parliament can be taken to have conferred a power which authorises the executive to abridge the basic principles on which the law of the United Kingdom is based, unless the statute conferring the power makes it clear that such was the intention of Parliament. Goes on, if Section 53 was to be construed in the manner suggested by the Attorney General, it would empower the executive to abridge the right to information guaranteed by the 2000 Act without any form of accountability, save for a rationality challenge. If Parliament intended to convey such a meaning, it would need to be crystal clear. It's at paragraph 58. Over the page, the language of reasonable grounds falls short of saying that a member of the executive can override the decision of a court because he disagrees with it. Paragraph 58. Lord Mans, with whom Lady Hale agrees, reached the same conclusion for similar, albeit slightly differing reason. At paragraph 129, they said the words reasonable grounds impose in any view a higher hurdle than mere rationality would be. Goes on to say the court must be able to scrutinise the Attorney General's reasons more intensively than the Wednesbury test permits, paragraph 128. And where the Attorney General uses Section 532 power to veto the decision of a tribunal that is undertaking a full judicial process, the courts will be slow to prefer the view of a member of the executive who has done no more than discuss the matter internally. That's at paragraph 130. So the Supreme Court's analysis, Stone will say, bears directly on this case. At paragraph 24, they point out that the matter concerns the basic principles of law of the United Kingdom is based, for the reasons set out in petition at paragraph 19. They say Section 35 power allows the executive, which has no democratic legitimacy, which we have identified from the case of Miller, no democratic legitimacy to veto the decisions of a democratically elected legislature. Parliament cannot be taken to have intended this power to be exercised merely on the basis that a member of the executive disagrees with a decision of the Scottish Parliament unless it used crystal clear language. As in Evans, the words reasonable grounds fall well short of the crystal clear statement required. Further, Stone will say, or in the alternative, the contrast in decision-making processes in the instant case mirrors that in Evans. The Parliament passed the bill after subjecting its provisions to the full rigour of the legislative process and 2 separate public consultations. By contrast, the Secretary of State merely consulted internally before making the order. The court may decide to echo Lord Mans and Lady Hale's reticence to endorse the latter in ahead of the former. And I say that in addition to how we set this the case of Evans out in the petition and the discussions we've had there, and my submissions on that today, the way in which Stonewall have explored this issue is done powerfully, and I say that their assessment of how Evans applies and the importance of this case is the right approach. So, as in Evans, in my submission, the court should not defer to the executive, the Secretary of State, in the manner that the Advocate General suggests. So, in summary, in my submission, a decision to make an order under Section 35 of the Scotland Act is one which calls for the sort of scrutiny suggested by Lord Phillips in RQ. Given the constitutional framework within which Section 35 sits, and the fact in particular that the decision amounts to an executive veto on legislation enacted by a democratically elected Parliament within its legislative competence, this is a case in which this court should look very closely at the process by which the facts have been ascertained and the logic of the inferences drawn from them. An intense review of the decision to make the order is necessary to maintain the critically important constitutional balance that I have explored earlier on in my submissions with my lady. This then leads me to the question of what is required of a decision maker by way of investigation or consideration before making a decision. What should the Secretary of State looked at before he made this order? What does the law say about that? The common law requires that a decision maker take reasonable steps to acquaint himself with the relevant facts and material before making their decision. This is often described as the tame side duty. After the case, Secretary of State for Education and Science against Tameside Metropolitan Borough Council, which is a 1977 appeal case. This is a PDF, page 644. And in that case, Lord Diplock said, the question for the court is, did the Secretary of State ask himself the right question and take reasonable steps to acquaint himself with the relevant information to enable him to answer it correctly? Now, I don't propose to turn up that case, since the principles relevant to Tameside were summarised by Lady Justice Hallett, sitting in first instance in the Divisional Court in the R. Plantagenet Limited case. That is on page 8 of my outline speaking note, my lady. I've made reference to that because what I can do is, I think both sides agree that this is a very helpful summary and it's worth turning up. It begins at page 822. The relevant passage is paragraph 100 at PDF 845, and I will read that, omitting the internal citations. So, number 1, the obligation on the decision maker is only to take such steps to inform himself as are reasonable. Subject to a Westminster challenge, it's for the public body and not the court to decide upon the manner and intensity of the inquiry to be undertaken. The court should not intervene merely because it considers that further inquiries would have been sensible or desirable. It should only intervene if no reasonable authority could have been satisfied on the basis of the inquiries made that it possessed the information necessary for its decision. Number 4, the court should establish what material was before the authority and should only strike down a decision by the authority not to make further inquiries if no reasonable counsel possessed of that material could suppose that the inquiries that they had made were sufficient. Number 5, the principle that the decision maker must call his own attention to considerations relevant to his decision, a duty which in practice may require him to consult outside bodies with a particular knowledge or involvement in the case, does not spring from a duty of procedural fairness to the applicant, but from the Secretary of State's duty so to inform himself as to arrive at a rational conclusion. The wider the discretion conferred on the Secretary of State, the more important it must be that he has all relevant material to enable him to properly exercise it. So that summary, my lady, has more recently been approved by the Court of Appeal in Balajari against the Secretary of State for the Home Department, which is at page 882 of the PDF and at paragraph 70 there. When Lady Justice Hallett talks of the Westminster challenge, that is subject to all that I have said about the intensity of review in these particular circumstances. When reviewing compliance, though, with the Tameside duty, again, I submit that the court should exercise a close review of what was done. Your ladyship will note at point 6, if the Advocate General is correct about the breadth of the discretion conferred by section 35, then we do land squarely within that territory. So having thus set out in some detail what I say are the relevant principles, both in relation to the standard of rationality review in general and the Tameside duty in particular, I then seek to apply them to this case. And there are 2 main limbs to the petitioner's rationality complaint about the order. The first is the Secretary of State did not fulfil the Tameside duty. And in any event, his conclusion that there were reasonable grounds to believe that there would be an adverse effect on the operation of law as it applies to reserved matters was not reasonably open to him. So dealing firstly with the Tameside duty and the advice which was given to the Secretary of State, this was provided to the petitioners in a partially redacted form on the 8th of August of this year. And it's been lodged in the second inventory of productions numbers 626 to 630. The main document, my lady will be familiar with these, is the submission from the Director of the Scotland Office dated 13th January 2023. It's in the petitioner's marked up bundle of documents as item 17 and on page 501 of the PDF. Further material, which it is said that the Secretary of State had before him when considering the matter, was provided later on the 11th of August, and this has been lodged as item 14 in the fourth inventory. I'll begin by looking firstly at the first advice and evidence provided by the Secretary of State before turning to what was not before him. The principal advice seems to be that contained in the submission to which I've just referred, which is item 17 in the petitioner's bundle of marked up documents. And mention is made in passing of the fact that there was support for the bill, for example, at paragraph 66 of that document. So does my lady have the item 17? Yep. So I've referred to the fact that there was support for the bill referenced at paragraph 66. But the focus of this document is very much about the opposition to and the concerns of the bill. The other documents produced with this document, drafts of the policy statement of reasons, an equality impact assessment, and brief updated advice, do not add to in any way, in any material respect for present purposes. The other material, which is said that the Secretary of State had before him, is in the respondent's fourth inventory of production, item 14, and that contains 7 documents. The note verbal, dated 29th November 2022, for the UN Special Reporter on Violence Against Women and Girls, which is at PDF page 2. The note verbal dated 13th December 2022 from the UN expert, independent expert on protection against violence and discrimination based on sexual orientation and sexual identity. Letter to the Minister for Women and Equalities from the Chair of the Equalities and Human Rights Commission, which is at PDF 27. Letter to the Secretary of State from the Executive Director of Sex Matters, attaching a briefing on the bill dated December 2022, PDF at 331, and the letter to the Secretary of State from Murray Blackburn Mackenzie, dated 2nd January 2023, PDF 58, and letter to the Secretary of State for Women Scotland, dated 3rd of January 2023, at 71 of the PDF, and letter to the Secretary of State from Keep Prison Single Sex, dated 8th of January 2023. I'm sure Malaria will be familiar with these documents. She will then that 6 out of 7 pieces of correspondence are hostile to the bill. The single exception is the note from the UN independent expert on protection against violence and discrimination based on sexual orientation and sexual identity. My lady will be aware that this expert on sexual orientation and sexual identity is an independent human rights expert who would be called upon by the United Nations to report or advise on human rights from thematic or country-specific perspectives. He acts independently from government and monitors sovereign nations and democratically elected governments and policies. So his was the only item that was in support of the legislation. That note is of some interest for what it says about safeguards and risks of abuse. And at page 24 of the PDF, the independent expert notes that as at the date of preparation of his opinion, more than 250 million people lived in countries with a legal gender recognition based on self-identification. Reading on to the following page, some 100 million are added by regional entities in a number of countries. The independent expert says, and I've got this at page 9 of my outline speaking note. My mandate has not received any information of administrative or criminal judicial findings that the self-identification process has been used by predatory men for the purpose of perpetrating gender or sexual violence against women in gender-segregated spaces in any of those countries or regions. And desk and online research to that effect has not yielded any results. Similarly, there are no reported cases that would support the submission that crimes perpetrated by trans women, trans men, or non-binary persons are the result of an abuse of system of legal recognition for the purpose of gaining undue access to segregated space or gendered-related differential treatment. In other words, the countries that have legal recognition of gender identity based on self-identification, there is no credible evidence to suggest systemic risk of predatory men using the process of identifying and living as a woman as an opportunity to perpetrate gender or sexual-based violence. The language is clear. There is no credible evidence. But we don't know what the Secretary of State made of this because he doesn't say. The Secretary of State has provided no explanation of why he considers it likely that the Scottish experience would differ from the international experience, if indeed he does think that. So, or put it another way, why does he have a reasonable concern, having been told that there's no credible evidence to support such concerns? Neither the petitioners nor my lady will know that. There's no answer to that. So echoing the words of Lord Keith in the case of R against Secretary of State ex parte Lonro in 1989 at 539 to 540, when the known facts point so clearly in one direction, having given no reasons for reaching a different view, the Secretary of State cannot complain if the court draws the inference that he had no rational reasons for his view. In my submission, that's precisely the inference your ladyship should draw. And in both Stonewall and Equality Network's interventions, they look in detail and make significant reference to international experience and the evidence that supports the system of self-ID. And I would refer my lady to Stonewall, paragraphs 2 to 9, and Equality Network at paragraph 4. So turning to the material that was apparently not before the Secretary of State, there is no indication that he considered to any extent the evidence considered by the Scottish Parliament in the course of the bill's passage, or evidence of experience in other jurisdictions which have introduced similar systems. There is little or no indication that he considered the positive impact of reforms contained in the bill on the lives of trans people, and your ladyship will get a flavour of that from the written submissions from the interveners. As I say, in both of the interventions, they also make the point that there's no evidence to support the Secretary of State's concerns, and there's no additional evidence that it's available to him to point to the opposite direction. So all the evidence from other jurisdictions was that there was nothing that the Secretary of State could rely on as indicating a reason for concern. In the petitioner's bundle of marked up documents, passages have been highlighted in the Equality Impact Assessment, item 6, beginning at page 251 and page 277 to 281. The Stage 1 report of the Equalities, Human Rights and Civil Justice Committee, dated 6th of October, That's item 7, Lady, beginning at page 301 and 321. And also, we've highlighted pages 367 to 375 and 382 to 388. And the draft response to the UN Special Reporter provided by the Scottish Government to the UK Government, which was Shona Robinson's letter, which answered the note verbal, which was number 1 on the list of documents that the Secretary of State relied on. Of course, Shona Robinson could not reply to that letter herself. It was one that required the response of the UK Government, but she did provide a draft for a draft response for the UK Government's use, and that is a very helpful document in setting down all of the evidence in the case that was looked at by the Scottish Parliament and the wide variety of sources and resources and evidence for the Scottish Parliament's decision making. So, as I've sought to emphasise, my lady, the policy reflected in the bill had been developed over years, undergone extensive consultation, and was one which the UK Government had been cited on from the formative stages. In my submission then, no Secretary of State could have reasonably considered that he was in a position to make a decision to exercise his power under Section 35 without having proper regard to arguments and evidence in favour of the bill as well as those against. That is all the more so when the arguments on both sides have been fully considered during the bill's passage through the Scottish Parliament, and the arguments in favour had carried the day by a large majority. If the Tameside duty means anything, and the Advocate General appears to accept the duty was engaged, then I say this: it cannot be permissible for the Secretary of State to shut his eyes to one half of the debate. If the duty to familiarise oneself with material can be met by picking a selection of that which supports only one side of the argument, then there would be no point in imposing the duty. If what was done here is held to be lawful, then in my submission, it would effectively empty the Tameside duty of any meaningful content. In taking his decision on the basis of limited information weighted against the contents of the bill, the Secretary of State failed in his duty to properly familiarise himself with the relevant evidence that was available to him. His decision was thus unlawful and falls to be reduced.
Just to be absolutely clear, when you describe the relevant evidence, you're talking about effectively all of the material that was available to the Scottish Parliament.
Yes,
during the panel.
Absolutely, and ladies, we'd be here for days if we were looking at it. And the ladies got all. No,
I'm not asking that. But I just want to be clear what you bring under the umbrella of the phrase relevant evidence.
Yeah.
So you're talking about the material that was before the Scottish Parliament through its various stages, in particular, I take it.
Yes, in particular, and we know, for example, there was expert evidence from, for example, the UN human rights expert. There was evidence from the chief statistician in Scotland as to the impact of the bill. There was input from all variety of organisations that looked at issues of equal pay, equality. All of these issues were explored in detail.
And so to fulfil the Tameside duty in this context, you say the Secretary of State was under an obligation to familiarise not only to actually familiarise himself with all of that material, but to make it clear that he had done so.
Exactly, and what he's done is he's listed 6 pieces of the material he's looked at, 6 pieces of hostile advice, hostile communications, and the information from an internal government department. He has not looked, as he was bound to do, to all of the evidence that was before the Scottish Parliament, the democratically elected legislature who then voted on the bill. following on plenary sessions and amendments.
How does that then sit with just looking for convenience, because it's very helpfully set out in your speaking note, Lord Advocate, at page 8, the reference to Lady Justice Hallett's summary of the duties. I think you said he was bound to look at all of the evidence. How does that sit with the obligation upon the decision makers only to take such steps to inform himself as are reasonable? That's always a very subjective phrase, I suppose, what is reasonable in any circumstances. And also the third, the court should not intervene merely because it considers that further inquiries would have been sensible or desirable. But do you say then that what was reasonable in this in this case was to look at all of the evidence that you've cited?
For all of the reasons that I've relied on, starting with the constitutional context, starting and then moving to the fact it's an executive veto of a decision of an elected parliament, which is of the highest legal authority, and in a context in which there was this wide-ranging available evidence, particularly from the information that was before the legislators of the day, who had the legal competence to pass the bill before the Parliament. He can't just close his eyes to one side of the argument. There would be no point in imposing a duty on him if that was acceptable. And I think that it's been pointed out to me that this is something that I touched on in my opening submissions on this point. Just look at paragraph 6 of Lady Justice Hallett's summary, my lady. It does say, the wider the discretion, the more important it must be that he must have all the relevant material to enable him to properly exercise it.
Yes, I wondered about that as well. Lord Advocate, are you approaching this from the assumption or presumption that this is a very wide discretion that is conferred under Section 35? Because I was just wondering, it's not an unfettered discretion, for example, permitting the Secretary of State to issue an order under Section 35 if he considers it reasonable to do so, full stop, for example, which would be a very wide discretion. There are fetters on it, as it were, the fact that there must be, as we've discussed, a modification of the law, that it must impact on reserved matters and so on. So where does this Section 35 discretion sit with paragraph 6 that you've taken me to, the wider the discretion? Do you contend that there is nevertheless a wide discretion under Section 35 or not?
That's not what I contend. That's what the Advocate General contends.
So
if I'm wrong and he's right, then
yeah,
the wider the discretion.
So that's really the S2 position for you.
Yeah. The point is, the Tameside duty has to be fulfilled.
Has to have bite.
It has to have a bite, or else where's the control? Where's the control for those against whom decisions are made by an executive in a situation such as this? So I might reflect on parts that
we are, of course, in uncharted territory, so I don't suggest for a minute there's necessarily an obvious or easy answer to this, but I wonder where this sits. We're not talking about, for example, a veto arising because of a question of competency, for example. I think seems to be common ground. There's no question but that this was a competent piece of legislation for the Scottish Parliament to pass. The veto arises because of the effect of that admittedly competent piece of legislation upon reserved matters. So there's quite a few sort of extra legs in it. Do you have any observations on that so far as the Tameside duty? Because a veto is not striking down the legislation simply because it was attempted to be enacted. It's a veto because of the consequences of that legislation.
Well, if I may, Lady, I'll think about that over lunch.
Yes, no, absolutely.
And I'll come back specifically on
yes.
this point after I've reflected on it over lunch. I think.
As we, I'm entirely in your hands, Laura. I mean, I'm conscious you have been on your feet a long time this morning. I don't know precisely where you are, but if you want to pick a good point to stop, even if that's slightly before 1 o'clock, that wouldn't cause me any difficulty. That may be now, or it may be in a few minutes' time.
So, yes, because it might help to stop now, because I was going to turn on to the material that I was looking at the material that wasn't before the Secretary of State, and I was looking at the Tameside duty, and then I was going to turn to adverse effects that the Secretary of State relies on. So it would help me to just adjourn now.
Yes, well, as I say, I'm conscious we didn't take a break during the morning, and you have been speaking for a long time. So we'll break for lunch now and return at 2 o'clock.
What?
Thank you, my lady. So just before lunch, we were, my lady had raised some issues over the import of the Tameside duty in this case, and
Yes.
I've given it some thought over the lunch break, and in order to try and respond to that, I've set down 4 propositions. I've actually typed them out so that your ladyship could
thank you.
at
Yes,
least have them to assist, hopefully.
that's very helpful. Thank you.
And I've alerted Mr. Johnson to the fact I've done that. So essentially what I was pointing out was that the Tameside duty placed responsibilities on the Secretary of State. And in order to be a meaningful duty, he would have to look at information that only didn't just support one side of the argument. And that's what I say he's done here. And the Tameside duty points that I would wish to highlight based on the questions that your ladyship was asking are these. The first one is this, and it relates to the constitutional significance of the decision of the Secretary of State. Given the constitutional significance of the decision to make the order, it being, as I've said, an executive veto of the act of a legislature whose democratic credentials are beyond question, what should be expected of the Secretary of State should be significant. My proposition is that, at the very least, the consideration of the issues must be balanced. The Secretary of State has told us what he considered, and on no view, I say, can that be said to be a balanced consideration of the issues. Indeed, to the extent that anything in support of the bill was before him, it concluded there was no credible evidence to support the concerns he went to rely on. If this is a broad discretion, and I've explained how Section 35 should be construed, I don't say it's broad, then point 6 bites against the Secretary of State. So if your ladyship accepts what is said about the subjective, evaluative and political nature of the discretion, then point 6 is plainly engaged. So if the Advocate General's approach to Section 35 is preferred, I say the demands of the Tameside duty increases. And in my submission in that situation, a fortiori, it cannot be said that he's met the requirements. And so the fundamental point is this, that the Tameside duty, if it means anything, if it's worth imposing, it cannot be satisfied in circumstances such as this, where so little has been considered, so partisan a body of material considered, to inform the taking of so constitutionally significant a decision, and I say that no reasonable Secretary of State could have thought it was. So I hope that to some degree answers.
No, that is extremely helpful. I think particularly your point 2 is, and I intend this as a compliment, not picking a point, but a more nuanced assessment of how that might interrelate with part 1 of the paragraph 1 of the Tameside duty. I think you obviously identified the concern I had was that you might perhaps be contending for an obligation on the Secretary of State to consider all of the material, or the same, and all of the material that was before the Parliament here. And I wondered if that was the position. But what you're saying now, as I understand it, is that it's not necessarily that the Secretary of State has to consider everything, but he must carry out a balanced consideration exercise. And that's a really helpful clarification, so thank you for that.
Thank you, Lady. I was also pointed out to me that I could have been a bit clearer on the Esther argument in relation to your ladyship's conclusion about Section 9 and how it interacts with the 2010 Act, and if that's changed. The point that I didn't make very well was that whatever ground it's changed on, the Secretary of State's House of Cards collapses, at least insofar as based on the bill's effect of the 2010 Act, which is, of course, the largest part of his reasons. So
So any overruling of For Women Scotland to any extent, you say?
In relation to Section 9.
In relation to Section 9.
But I'm sure, well, lady,
yes.
So that's something that I hope
clarified. Yes, thank you very much.
So just moving on then, turning to adverse effects, the Secretary of State purports to rely upon various concerns about the effect of the bill. And my general submission here is that they are either unfounded, too speculative or hypothetical, or insufficiently cogent and material to justify the exceptional step of making the order. There's a good deal of overlap between this aspect of the rationality challenge and the challenge in relation to adequacy of reasons in Schedule 2 of the order. I'll deal more with the reasons in relation to the order in the final chapter of my submissions. But in summary, on grounds of his failure to comply with the Tameside duty and the inadequacy of the reasons relied on, the Secretary of State's view that the bill would have an adverse effect on the operation of law as it applies to reserved matters was not reasonably open to him, and his decision falls to be reduced. So, moving on then to irrelevant considerations, and that reflects the note of argument at paragraphs 45 to 49. This ground of challenge is also directed at condition 2, which your ladyship will recall is the requirement that the Secretary of State must have reasonable grounds to believe that the provisions would have an adverse effect on the operation of the law as it applies to reserved matters. The petitioners contend that because the Secretary of State has had regard to irrelevant considerations, or put it another way, has acted irrationally in having regard to those considerations when making his decision, the decision is unlawful and should be reduced. Again, I'd like to refer my ladyship to some of the law applying to the case before the court. And to begin with, I'd like to point out that a decision maker may be faced with 3 types of consideration. That is, those that they're required to take into account, those that they are required not to take into account, and those which they may choose for themselves whether or not to take into account. Failure to have regard to the type 1, those they are required to take into account, consideration or taking into account a type B consideration, those that they're required not to take into account, will vitiate the decision. So, not to adhere to 1 or 2, as I've pointed out, vitiates the decision. The obligation in respect to type 1 and type 2 considerations can be implicit or indeed explicit in a statute. For a type C consideration, that is those which they may choose for themselves whether or not to take into account, the touchstone is irrationality. Was it irrational for the decision maker to take into account or leave out of account that consideration? And so this very short account of what the law is vouched in the note of argument by reference to a number of cases. The first is Hurst against London Northern District Coroner, and I refer to paragraph 57 in that case, which is at PDF number 497. Credence Incorporated against Governor General, 1981, which is at PDF page 545, and that's to a reference at page 183 and paragraph 57, where the statements of Cook J were approved by Lord Brown and Hurst. I don't believe these principles to be in dispute, so don't propose to turn up the cases. But I note that at paragraph 5.6 of his note of argument, the Advocate General relies on RDSD against Parole Board, which is PDF page 844, and he points to paragraph 14 of that decision. That case, DSD, contains a summary based on credence by the Divisional Court, which I say adds nothing to the foundational authorities I've just mentioned. But it's clear that the Advocate General contends that any considerations were type C conditions, and thus the threshold was irrationality. I take issue with that analysis for the reasons I'm about to come on to. And the first relates to the issue of divergence. So, applying these principles to the case before the court, in my submission, the Secretary of State has, in two respects, relied on irrelevant considerations. The first of these is divergence between the law of Scotland and the law of England and Wales as a consequence of the passage of the bill. That is an irrelevant consideration. And of course, it does feature heavily in the reasons set out in Schedule 2 of the order, being mentioned at paragraphs 4a and 6 to 9. I'm going to come on and look at the schedule to the order a little later, but divergence is certainly one of the most significant issues relied on by the Secretary of State. In relation to divergence, it's my submission that divergence between the law of Scotland and the law of England and Wales as a consequence of the passage of the bill is a type B consideration. In other words, it's a consideration which the Secretary of State was required not to take into account. I say that because, as I've already submitted, gender recognition is a subject which the UK Parliament has permitted the Scottish Parliament to legislate on, and hence has permitted Scots law to diverge from that of England and Wales. Whether to permit divergence on this matter is a policy question which has been answered by the UK Parliament. Accordingly, it is by necessary implication of the terms of the Scotland Act a matter which the Secretary of State is required not to take into account. Or to put it another way, the UK Parliament has determined that divergence or dual system is acceptable. It is not open, therefore, to the Secretary of State to have regard, as he has done, to the fact of a dual system. The Secretary of State claims in his motive argument at paragraph 5.8 that it's not the fact of divergence itself, but the effect of the particular examples of divergence. However, my point is this: the logic of the reasons relied upon in Schedule 2 is that the Secretary of State objects to and would presumably veto any divergence, at least where that would lead to people having a different gender in Scotland than in England and Wales, or would lead to a significant increase in the number of gender recognition certificates being issued. For example, the HMRC issues relied upon are not tied to this particular scheme. The objection to the HMRC issues lies in an objection to divergence in itself. If your ladyship's not with me on that principal submission, my secondary position is that divergence between the law of Scotland and the law of England and Wales as a consequence of the passage of the bill is a type C consideration to which it was irrational for the Secretary of State to have regard. It was irrational for him to do so, given the fact that divergence between the law of Scotland and the law of England and Wales on this matter is envisaged and is allowed by the statutory framework. The second irrelevant consideration relates to the suggestion of an increase in fraudulent applications and a concern over the new cohort of those who are applying for the certificates. So the Secretary of State's reliance upon concerns about increased fraudulent applications as a consequence of there being, in his view, more limited safeguards is, in my submission, an irrelevant consideration. This features in Schedule 2 of the order at paragraph 4b and 10. The reason that this is an irrelevant consideration can be stated succinctly and follows logically from the submissions I made earlier about the proper purpose of an order under Section 35. Your Ladyship will recall my submission that the proper purpose of an order under Section 35 is to block royal assent of devolved legislation which has an adverse effect on the operation of the law as it applies to reserved matters. It's not to block royal assent of devolved legislation where the Secretary of State considers different policy choices could or should have been made. In any event, there are no reasons offered in the order to explain why, contrary to the experience of other jurisdictions, the Secretary of State is apprehensive of this being a problem in Scotland and or the wider UK. It ties in with the submissions I've made about the Secretary of State having failed in his duty to familiarise himself with the relevant available evidence. And I do remind my lady of what the independent expert said in relation to this notion of an increase in fraudulent concerns, which is there's no credible evidence to support that. And the approach that I take on this is also reflected in the interventions by Stonewall and Equality Network. Stonewall and Equality Network refer to the international evidence that was available to the Scottish Parliament. Stonewall at paragraphs 6 through to 9 look at this in some detail. I don't intend to read all of it out, my lady, but they point out that an examination of the international context reveals the respondents' concerns have not resulted in harm in other jurisdictions where a system of self-ID had been adopted. And the paragraphs 6 through to 9, they look at evidence available in support of that. But what they say at paragraph 9 is essentially what I say, is that the Secretary of State has presented no argument to suggest that the Scottish experience will differ from the international experience as regarding fraudulent applications, and his concerns are accordingly misconceived and unreasonable. So he has no evidence to reject the formidable body of evidence that supported a different view from his. So for these reasons, I say that the Secretary of State's decision proceeded to a material extent upon irrelevant considerations and thus falls to be reduced. The Equality Network cover this issue in paragraphs 24 to 27 of their intervention. And the last part of my submissions, my lady, deals with reasons. And I'd now propose to go on to the reasons challenge. And that's focused in our note of argument at paragraphs 50 through to 54. This ground of challenge is directed at condition 3, namely the requirement to provide reasons. And so whilst Schedule 2 to the order contains what are said to be the reasons for making it, in my submission, these reasons are inadequate in law. And it follows that condition 3 has not been satisfied, and the order in this ground too, in addition to the others I've already covered, should be reduced. So again, I deal with the applicable legal principles before applying them to this case. And I start with the proposition about which I don't consider there to be any dispute. Reasons must leave the informed reader and the court in no real and substantial doubt as to what the reasons were for a decision and what were the material considerations were taken into account in reaching it. And of course, that the referable authority is Wardy Property Company against the Secretary of State for Scotland at page 348. The PDF number is page 581. So I see this, lady, where the legislature has imposed an obligation on a decision maker to provide reasons for a discretionary decision, the common law has long required that those be of a sufficient quality to discharge the statutory obligation. And in this connection, I refer to Lord Reid's statement, paragraph 70, in the case of Chief Constable against Lothian and Borders Police, decision from 2005, paragraph 70. It's PDF 505. Or I perhaps put it this other way. Where Parliament has required that reasons are provided, it is presumed to have required that the reasons be adequate by the standards of the common law. So an obligation to provide reasons is an express condition of making an order under Section 35. That the UK Parliament intended the requirement to provide reasons as a condition of the validity of a decision to make an order under Section 35 is clear from the language used in subsection 2, which says the order must state reasons, and the fact that the obligation is contained in a specific subsection. In my submission, the provision of reasons is therefore a matter of substance, not form. Yes, the Secretary of State can point to Schedule 2 to the order and say, these are my reasons, but if those reasons aren't adequate by the standards of the common law, then they do not meet the statutory requirement and the order should be vitiated. So when considering whether the Secretary of State has discharged the statutory obligation imposed on him by the UK Parliament, these propositions need to be considered. It is the reasons produced with the order which fall to be scrutinised. So we need to look to the order to scrutinise the decision, and the intensity of the review is greater than what was classically understood as the Westminster assessment. So we look to the order to see his reasons and to scrutinise those.
So
and
I'm sorry to interrupt, just to be clear, you may be coming on to say this, but what do you say then is the status of the public statement of...
The statement of reasons?
Yes.
Well, I say that the law required the Secretary of State to reference his reasons in the order, and the order stands or falls by those reasons. And it's not open to this court to look at the statement of reasons. I see that Stonewall and Equality Network and others may have referred to those insofar as highlighting the inconsistency between some of the language in the statement of reasons and the order. But if we're applying the legislation correctly, my position is that the order stands or falls by the reasons provided in Schedule 2. So
what is the relevance, do you say, then, of the policy statement of reasons?
I say it's not relevant to my lady's consideration. But if it is to be looked at by my lady in any context, it's simply to show that there's a real question mark over the reasons in the order for the reasons I've said before, because many of these reasons have morphed from may, could be, possible to an absolute. And so for me, in my submission, if my lady's going to look at them, she needs to look at them in order to decide whether or not there's sufficient reasons, but also to decide whether or not they reach the standard required to meet Section 35.
Yes, I'm just sorry. I'm just looking again at the actual specific wording of Section 35.
It says the order shall state the reasons.
Oh, yeah, no, it does. Yes, I'm just wondering and looking at it a little bit more holistically. It says if a bill contains provisions which the Secretary of State has reasonable grounds to believe, and so on, he may make an order. And then it does go on to say the order must identify the bill and the provisions in question and state the reasons for making the order. So that does seem to tie it to the order.
But as the point that I would say,
the only query in my mind is how that interrelates with how one assesses whether the Secretary of State had reasonable grounds. There may be some relevance to the policy statement of reasons.
So yes, I can see that. But so in that context, it would be legitimate to comment on inconsistency between the statement of reasons and Schedule 2, which I think is what some of the interveners have done to a greater extent than I have done. So applying these principles to the case before the court, in my submission, the reasons in Schedule 2 of the order are inadequate in law. They are flawed in a number of ways, and it may be useful if your ladyship has Schedule 2 of the order, which is at page 7 of the PDF. And its heading is Schedule 2, Reasons for Making this Order. Article 4, Identification of the modification of the law as it applies in reserved matters, and then assessment of adverse effects and the like. So I know my lady will have read this before today, but it might just be helpful to have this in front of her as I make my submissions on the reasons contained in the order and why they're inadequate. So firstly, as I explained earlier in my submissions, the creation of different regimes for issuing gender recognition certificates and concerns about safeguards are irrelevant, and that flaw affects paragraphs 4A and B and 6 to 10 of the order. 4A and B and paragraphs 6 to 10 of the order. The main grounds of concern advanced by the Secretary of State relate to the effect which he claims the bill will have on the 2010 Act, and that's particularly focused in paragraphs 4C, 7, 11 to 12 of the order. So the main grounds of concern advanced by him relate to effect, and these are at paragraphs 4C, 7, and then 11 to 12. For reasons I have explained, the bill does not have an adverse effect upon the operation of the law in that Act. The essence of many of the concerns is that issues which already arise or might arise under the current law may arise more often, and that's contained at paragraphs 11 and 12 of the order. And that is so of nearly all of the concerns related to the Equality Act. I referred earlier to the submission to the Secretary of State from the Director of the Scotland Office, dated 13th January 2023, which is item 17 in the petitioner's marked up bundle of documents, PDF page 501. And if my lady looks at paragraphs 45 to 51, beginning at 510, she will notice that the problems relating to clubs and associations, operation of the public sector equality duty, comparator measures, and provisions where exceptions apply for both sex and gender reassignment are acknowledged to be concerns which, it is said, arise already as a result of the GRC process provided in the 2004 Act and its interaction with the 2010 Act. And specifically, my lady, I would ask you to look at paragraph 50 of that. Have you got got that? Douglas? The page 50 of the PDF 51. Yeah, okay.
Paragraph
50. Yes, that's right.
I'm sorry, I should remember to put my microphone back on when I'm speaking. I've got that at page 512 of the PDF.
Yeah. Thank you, Lady. That's very helpful. So, paragraph 50, I think, is worth looking at because it says this. The Scotland Office says this. In considering the four issues set out above, it is important to recall that these concerns arise already as a result of the GRC process provided for by the 2004 Act and its interaction with the 2010 Act. As highlighted above, there are some provisions available under the 2010 Act in mitigation, such as exceptions that allow for exclusion on grounds of gender reassignment where justified, but they do not cover all issues or address all concerns. But they're not new issues and they're not new concerns. And I pause to observe then, my lady, that
I suppose, but if we read on, it doesn't say central to the concern about the adverse effects of the bill is that these existing problems will be increased and exacerbated by the greater numbers of. I read it out only because I suspect Mr. Johnson might do so in due course. So, increase and exacerbate the greater number of GRC applicants, changes to the cohort, and the increased ease of obtaining a GRC.
But what essentially has not been demonstrated by the Secretary of State by reference to any evidence is that a numerical increase in Scottish gender recognition certificates would have any impact, let alone an adverse effect on the operation of the law. He would need to demonstrate a statistical significance, for example, in relation to the public sector equality duty, and why it cannot be addressed, mitigated, or ameliorated. It's not good enough to say there's going to be more of these, so the bill passed by the Scottish Parliament can't stand. He has to have an evidential basis to support his proposition. So they're not new effects. There may be an increase because of the numbers, but what does he say in the available evidence that he has proposed demonstrates that an increase alone has an impact and an increase alone has an adverse effect on the operation of the law? He simply hasn't done that.
Can I explore with you a little bit the proposition that there's an obligation to have evidence and what might be meant by the phrase evidence? I think I've noted you saying he would need to demonstrate statistical evidence, for example, in relation to the public sector equality duty, and an evidential basis to support the proposition. But how does that intersect with, well, firstly, the first Tameside duty, that the obligation is only to take such steps to inform himself as are reasonable, and separately, and I've fully noted your submissions in relation to what the petitioners assert was a lack of engagement beforehand, but putting that to one side for the moment, how does that intersect with the 4-week window provided in section 35? If we left the concerns about the lack of engagement or discussion beforehand, what the statute provides for is a 4-week window within which to determine whether or not to make an order under section 35, and also the obligation to take such steps as are reasonable. I'm just wondering how that all fits together, because it might be said to be quite an onerous obligation to ingather statistical evidence to support or justify the proposition that there is that this proposed legislation is going to have an adverse effect. But you say that is would that apply?
So he has to have some evidence. He has to have something to point to. And what I say is that there's no evidence or cogent explanation that's been provided about the proposition that the issues amount to problems in the operation of the law as it stands. So we're looking at the law as it stands. And what we know is that there's not been any consideration given previously sufficiently seriously to require amending legislation to be brought forward. And we're not noted as concerns in the UK government's own consultation about updating the Act. But be that as it may, the main theme of my submissions is that the bill doesn't affect the law as it applies to reserved matters. And my submission is this: more people using or falling within the scope of a legal provision doesn't constitute an effect on the operation of the law. To put it another way, Section 35 requires an impact on the operation of the law itself, not merely on its application on the facts of any given scenario. That is all the more so when the numbers of additional people who are likely to get the Scottish Gender Recognition Certificate is very small in relation to the population of Scotland, and smaller still in relation to the population of the United Kingdom. And the Scottish, the work that was done by the Scottish Parliament explored the numbers, and the lady has seen those numbers in the documents that are before her, and she will see that it is a very small number of people in relation to the population. So there are different ways of evidencing things, of course. You can get statistical evidence, you can get expert evidence, you can do your own groundwork and work out numbers and see how what the impact's going to be. You can do all of that, but that's not been done by the Secretary of State. It's just a general assertion that there's going to be more, so it's going to be difficult. And that just isn't good enough in terms of the order. And what is even more important is that, something that I've said before, more people using or falling within the scope of a legal provision does not constitute an effect on the operation of the law. So, as I've already emphasised, the Secretary of State's concerns are almost...
Sorry, I'm a time lag behind you, Lord Abigail. I'm sort of absorbing things as you're saying this. Apologies for cutting across you. It's just your proposition is that more people using or falling within a provision, I suppose it could be any provision, really doesn't constitute an effect on the operation of the law. But if we had an amendment to the law that suddenly, not within the actual context that we're talking about, but suddenly entitled many more people to use NHS services, say, or something that's going to increase, maybe not in pure numbers, but say people, if we altered the law so that people with a particularly acute condition were entitled to access certain aspects of the NHS, say, that would be an effect on the operation of the law, would it not, in terms of entitlement to use a service? Or no, you think that would...
So the law operates, law...
wasn't the law particularly
operates particularly in accordance with rules. Those rules will not change, and the application of those rules will not change, because you increase the number of people who would be likely to obtain a Scottish Gender Recognition Certificate. And so what's also really important, though, is to know whether or not the evidence supports this reaction to an increase in numbers, because it will be a very small number in relation to the population of Scotland. And what we do know from our investigations is the UK Parliament has reduced its application fee in relation to gender recognition certificates, which can now be done online. And what we know is that the increase in applications by that it would certainly not be anything. It would be far less than is projected. It's far more rather than is projected by the bill for the Scottish certificate. So his concerns about increase caused by the bill, when seen in the context of the UK government having changed the requirements, causing a bigger effect, leaves one to really question his evidential base for identifying the Scottish gender recognition certificates as causing the enormous problems that he suggests are being caused.
So this is not a straightforward area. There's little that is straightforward, perhaps, Lord Advocate, but the wording of Section 35, and this is just an observation, it is worded as it is, but it doesn't contain a qualitative or conditional aspect to it, by which I mean it simply says that if the bill contains provisions which make modifications and which the Secretary of State has reasonable grounds to believe would have an adverse effect on the operation of the law, that, I suppose, does open up the potential for a subjective assessment on that, because it doesn't say, for example, reasonable grounds to believe would have a significant adverse effect, or numbers, qualitative numbers are not introduced in any way, and that's just the language of the provision. But does it, or what is your position? Does it leave open a degree of discretion to the decision maker as to what an adverse effect is, which might not necessarily be evaluated in terms of pure numbers, I suppose?
Well, the Secretary of State has relied on an increase in numbers, and that being an adverse effect on the operation of the law as it applies to reserved matters. That gives him reasonable grounds to believe. So
yes, that's a fair point. That is. Yeah.
So he's got to be able to say what his grounds are and why they're reasonable. And he relies on an increase in numbers per se and a different cohort of individuals to come to this very significant conclusion in the context of Section 35 order, when he's only exercising executive competence to say that it's going to have an adverse effect on the operation of the law. And I say what's simply wrong in that. It's he has no evidential basis for his assertions, and the standard of review that my lady has to have in this case must be one that's of anxious scrutiny for the reasons that I've set out before. We looked at Evans, we looked at the Tameside Beauty, we looked at the constitutional context of all of this, and it all bears on how my lady reviews the decision. But fundamentally, just on this point, just more people using or falling within the scope of a legal provision doesn't constitute an effect, doesn't constitute an adverse effect on the operation of the law. And the Secretary of State really would have to point to why it is that Scottish gender recognition certificates would do exactly that, when, as I say, the changes that have been made by the UK government have increased the number of gender recognition certificates applications beyond anything that the Scottish gender recognition certificate process would increase. So he really has to have an evidential basis. And my point is, he doesn't have that.
So I absolutely take what you're saying, Lord Advocate, as read, but there's nothing in this, the information that you've got. Have I missed anything in the bundle? There's nothing about the increased applications under the existing UK legislation in the bundle. But
I will be able to give those figures because they're available online.
Oh, I see.
Yeah, I'll be able to give those after today and this evening, and I'll check them with Mr. Johnson. But what I'm emphasising is the Secretary of State's concerns are almost entirely unsupported by evidence. And that is especially so in relation to concerns about safeguarding and fraudulent or malign applications. And he's made that in paragraphs 4b and 10 of the order. These concerns are inconsistent with experience in jurisdictions which have introduced similar provisions as those contained in the bill. It's worth pausing to recall that the Secretary of State, in relation to section 35, and this is something I think the lady was touching on, may intervene where he has reasonable grounds to believe that the bill would have an adverse effect. So the belief must be grounded in evidence, or at least grounded in a cogent analysis and explanation. And your ladyship will recall the point I made about the question of divergence. What for the Equality Hub may have been an issue, morphed without reason or explanation into something that would be a problem. And Stonewall, at paragraph 28 of their submission, give other examples of the Equality Hub raising what were only possible issues. And I think it'd be worth just looking at Stonewall's paragraph 28.
Just bear with me one moment, I'll just get that.
Yes, so, yes, it's on page 11, standard of scrutiny. The standarding point must be the language of the provision itself. The Secretary of State has reasonable grounds to believe that the bill would have an adverse effect, emphasis added. The Secretary of State has, in relation to a number of reasons, in the statement of reasons, merely concluded that certain allegedly adverse impacts could potentially or may occur. And Stonewall point out that regard should be had to paragraphs 18, 21, 35 to 37, 41 and 44. So at the very least, I say, my lady, this creates the impression of a transformation occurring simply as to fit the reasons given to the statutory test that the Secretary of State had to meet. And going back to the order, several of the reasons raise hypothetical and theoretical concerns which are very unlikely to arise in practice, or at least may arise very infrequently, or are not cogently explained. That is so, for example, in relation to the effects of the equal pay claim. That's at 6C of the order. So just 6C of the order. I've got the right part. Yeah. 6C. Yes, of course. Yes, 6C. Yep. No, it's 4C. Mm-hmm. I'll get the right reference, my lady.
6C of
is, sorry.
I don't think it's 6, is it? Oh, sorry, I'm looking at the wrong thing here. Just
equal pay, yes. It's 7C. I'm so sorry. Yeah, I'm so sorry. It's 7C. Yeah. So just looking at that, it says equal pay. An employer operating across the UK could have employees who could not use a colleague as a comparator in an equal pay claim if it were brought in Scotland, but could do so in England and vice versa. And the language of could is concerning, obviously. And what's significant from the Equality Network's intervention is that they point out that paragraphs 30 and 31, why there's so much more to this issue and requires more analysis than the very succinct way in which this is dealt with at 7C, and which doesn't actually say why there would be an adverse impact on the operation of the law in relation to equal pay. Equality Network put it well at paragraphs 30 and 31 of their intervention. And they point out there, my lady, that page 10, paragraph 30 of their intervention, equal pay claims, strictly speaking, claims for breach of the sex equality clause in a contract of employment under section 66 are capable of being brought either by a man or a woman citing a comparator of the opposite sex. For any equal pay claim to succeed, an employment tribunal has to conclude that the comparator is paid more than a claimant of the opposite sex for doing equal work, and that the employer hasn't demonstrated that the difference of pay is because of a reason, that's a material factor that's required by section 69. And so they point out that on that analysis, it's by no means axiomatic that an employee acquiring the opposite gender upon obtaining a gender recognition certificate will expose an employer to a well-founded equal pay claim. Indeed, it's possible for claimants to raise equal pay claims citing comparators of the same sex, where their claims are contingent upon a successful claim made by a colleague of the opposite sex against the same comparator, known as piggyback claims, which we're all familiar with from the case of Hartlepool. So equal pay, 7C, it certainly doesn't meet the standard of section 35 as narrated in the order. And in relation to 12C, sure I've got the right paragraph. That's not quite the right paragraph, C. That's 12C relates to single-sex school admissions. That's not where I'm at. I'm at the single-sex clubs. That's 11. Well, it's 12. 12C should be. Okay. Oh, yes, that's correct. Thank you. 12C is equality of terms. That relates to an equal pay claim as well. So they say that in 12C, just on equal pay also, I'm sorry, getting slightly confused here, they go on at the end, the order goes on to say...
12 deals with the particular provisions of the 2010 Act, the Associations of Public Sector Equality Duty, and then the equality of terms, and particularly referencing equal.
Yeah, so 12C, my lady, also deals with that. And then remembering what the test is, ultimately 12C, what the Secretary of State says, this may lead to the comparative test identifying an equal pay issue where one does not properly exist or failing to identify such an issue. An increase in the number of people holding gender recognition certificates may increase the incidence of this issue. I mean, that language is just not, does not meet the statutory test. So that's paragraph 6C and 12C, 7C and 12C, I'm so sorry.
I don't know where we draw the line. If the decision maker in this case thinks that something may happen, you say, I think it's implicit in your position, you say that that does not amount to a reasonable ground. So a reasonable ground has to be founded on something more solid, yes. You say, an evidence-based.
Absolutely, yes. And that it would have an adverse effect on the operation of the law. In relation to single-sex clubs or associations and sex-segregated spaces and services, that's dealt with in paragraphs 7B, 10, 12A and 12D. I say that Stonewall and others point out in their written submissions at paragraph 10 that if identification is required for access, the commonly used types of identification in the UK include documents with sex markers, which can be altered without the need for a gender recognition certificate. Examples include driving licenses and passports, and I believe it is correct to say that it will be within judicial knowledge that birth certificates are virtually never required. Leaving that aside, the point's a good one, because the most common forms of identification have gender markers which can be and are changed without having obtained a gender recognition certificate. So at best...
Is that it's really just a point of education, man. Is it possible to change your passport without
That's right.
a matching birth certificate? That there's a forest of nodding going on behind you, Lord Abbey.
That's right, yes.
It's really, as I say, so if trying to remember the last time I applied for a passport, if one applies for a passport, it's lost or stolen, say, you don't need a birth certificate to go with it that matches your...
Driving license and passports are examples that are given.
I appreciate. I'm not doubting that. It just somewhat surprised me to learn that.
That's correct.
But you adopt what
you can change. Yeah. So you can change the sex marker without a birth certificate.
Let me just read again what they. Sorry, I'm just looking at the Stonewall intervention.
That's certainly something that both Stonewall and Equality Network have dealt with in their interventions.
I mean, I remember reading this, but I and it's not a criticism at all, but I didn't fully understand where it's on paragraph 10, as you've identified. If ID is required to access single-sex services, the commonly used ID in the UK includes sex markers but do not require GRC to alter. And examples that have been offered have been driving licenses and passports.
Yes.
But it's your understanding that that's right, that to proffer a passport or a driving license, you can change that at will, in effect, without...
Yes. And I think that was explored in the evidence before the Scottish Parliament. Okay.
So a person who identifies as born with male on their birth certificate, who identifies as female, could request a new driving license with female on it, albeit they hadn't gone through the process and they still have a birth certificate saying male. Is that your understanding?
And I can show my lady the...
But it's a point of education for me, really, just to have a full... I wasn't...
There's available guidance online for passport gender change, and I can give that to my lady to show that what I'm saying...
I've already distracted you enough, Lord Advocate, from your line. So it was a point that was of interest.
You can get that. Yeah. So I believe it's correct to say that birth certificates are virtually never required, and that the most common forms of identification have gender markers which can be and are changed without obtaining a GRC. That was certainly the evidence before the Parliament. It's in the intervention, and we'll get the detail that shows that to my lady. So at best, I say the effect on such things as single-sex spaces is likely to be extremely modest. In relation to the public sector equality duty, which is at paragraph 6b and 12b of the order, there is no evidence to support the assertions made about the challenges in relation to the public sector equality duty. So that's 6B and 12B. So 12B, I have it open here, which says an increase in the number of people holding gender recognition certificates will make it more difficult to monitor UK-wide disparities between men and women or transgender and non-transgender people if membership of this group differs between Scotland and the rest of the United Kingdom. And 6B,
I think might it be 7B?
I'm sorry.
No.
I've put the wrong number in my submissions, which is why I keep saying
I think it's 7B.
7B. Yeah, the public sector equality duty, a cross-border public authority would have to apply this public sector equality duty differently as regards Scotland and England and Wales. So what I say about the reference to public sector equality duty is that it's relatively generic and reference is made to data collection and impact assessment, and it's really not explained precisely which provisions are at stake, nor are they cited or analysed in any detail. And the intervention by Stonewall looked particularly at the public sector equality duty and dealt with it extremely well in their intervention. And just to go to that part of their submission. So it's at page 12 and it begins at paragraph 33. They say, and I agree with this, that there's no cogent evidence which supports the conclusion that the proposed reforms would have adverse effects on equality laws in the way asserted. It then goes on to say, at paragraph 34, that they're going to deal with the public sector equality duty, and in this regard, they submit that A, in the statement of reasons at paragraph 38, it's asserted that the bill will mean that decision makers will not always be considering the impact on biological women as distinct disadvantaged group compared to the impact on biological men. This is described as an existing problem. However, no supporting detail or evidence has been provided for the assertion that this is a problem at present. I'll also say, nor is there any evidence provided for the assertion that the bill will make the so-called problem worse, which is said to be due to an increased number and range of GRC holders. In terms of evidencing the number of GRC holders, the only data sets referenced in the SOR appear to be the Scottish Government's own data. As for range, the SOR describes a new and very different cohort, different diversity, paragraph 50, and its heterogeneity at paragraph 25. The respondent does not explain why heterogeneity or difference per se would lead to adverse effects. Moreover, as the Scotland's chief statistician has stated, it assumed that the vast majority of official data is already collected on the basis of self-defined sex, for example, asking are you male or female, without providing any guidance as to how people should interpret the question. It's therefore unclear why an increase in GRCs would impact substantially on all data collection. The SOR fails to demonstrate that a numerical increase in GRCs would have any impact, let alone an adverse one. However, even if this were in principle possible, the UK government would need to demonstrate that the expected increase would statistically be significant vis-à-vis public sector equality duty data, and also why such an adverse impact could not be addressed or mitigated, for example, changes in the survey methods. It has also failed to do so. By way of comparison, quantitative analysis has indicated that self-declaration would not have a meaning on impact a meaningful impact on gender pay gaps. And they quote the submission that was put before the Scottish Parliament there on that particular issue, Close the Gap, which is in the documents my lady has. But dealing with the public sector equality duty, the Stonewall point out at paragraphs 36 to 37 that the Secretary of State is mischaracterised in the Statement of Reasons. It points out that there's reference, as I said, reference to the public sector equality duty is generic and makes reference to data collection and impact assessment, but doesn't actually say precisely which provisions are at stake, nor are they cited or analysed in any detail. And the respondent's note of argument provides no further clarification. However, as they point out, the public sector equality duty is multifaceted and involves more than just data collection. For example, compliance may involve training decision makers or engagement with service users. Indeed, as the Equality and Human Rights Commission's guidance notes state, there's no explicit legal requirement under the general duty specifically to collect and use equality information. As such, the Statement of Reasons fails to adequately explain and justify its assertions about adverse effect. And I say that that is applicable also to the order that we've looked at. And I think it's important to see what Stonewall say at paragraph 38. They say the Statement of Reasons at paragraph 38 says that it is possible that the creation of a larger cohort of people with GRC will have an effect on the application of the public sector equality duty. Quite apart from the fact that mere possibility falls short of reasonable grounds to believe, Section 35 requires an impact on the operation of the law itself, not merely its application of facts of a given scenario. They point out that this error is repeated in paragraph 39, where it said that public sector equality duty will be more difficult to apply if reforms go ahead as a result of the bill. So even if the adverse impacts canvassed were compelling on their facts, which they're not, Stonewall says, they relate not to the operation of the public sector equality duty as a legal duty itself, but rather to the perceived practical difficulties of applying an existing, unchanged set of legal principles post-reform. And more broadly, the underlying concerns of the respondent in respect of the impact on equalities law appears to arise from a belief that the composition of the group of people possessing a protected characteristic, namely sex, may be broader post-reforms. As such, the Statement of Reasons at paragraph 40 says the laws requiring public bodies to monitor and respond to that change, that is the public sector equality duty, may return slightly different results following the enactment of the bill, having an effect on the interpretation of such equality monitoring. But they point out that this is a social change which equality monitoring data will track, not a change in how the law operates. And I endorse those arguments and also those that are contained at paragraph 41 of the note. And in some ways, paragraph 41 deals with the point that my lady was making, because they point out that policy or legislative choices will often impact on practical circumstances in a way that has an inevitable secondary impact on data collection for public sector equality purposes. For example, policy reforms may result in improved healthcare or increased immigration. These could result in demographic changes that alter the composition of a number of people in the UK possessing the protected characteristics of, say, age or sex. Equality monitoring will then reflect these changes. Significant shifts of this kind may require new interpretive techniques or new questions to be asked. Where there is a material change in policy, it may be necessary to adapt data monitoring techniques in order to comply with equalities monitoring duties, for example, asking a different question in the survey. But none of this suggests that there will be a change to the operation of the law. The petitioner's submission, that is my submission, that more people using or falling within the scope of a legal provision doesn't constitute an effect upon the operation of the law is correct. And they point out that the respondent has admitted in paragraph 18 of his answers that the effect of acquiring a Scottish gender recognition certificate under the bill would remain that prescribed by section 9 of the 2004 Act. So in relation to the public sector equality duty, my submission is the same, that there's simply not cogent reasons demonstrated by the Secretary of State in relation to this issue that would warrant the use of a Section 35 order. And the statement in the schedule is not sufficient reasons for that decision that was made by the Secretary of State to quash, or rather to invoke Section 35.
Is there a distinction, and it may not be a distinction to be made, looking at the points made by Stonewall? They seem to be, I may be reading too much into it, they seem to be proceeding. For example, in paragraph 41, they talk about UK equalities monitoring and so on and so forth. But we're not talking here about a policy reform that may result in improved healthcare or increased immigration that's going to apply UK-wide, and in relation to which, obviously, things like data collection would have to respond and react to reflect the new reality. But we're talking about different regimes operating in different parts of the United Kingdom, and that seems to me that might be a distinction to be made between the points that are, or from the points that are made by Stonewall here, that we're not talking about a significant shift applying across all of the devolved administrations and the UK as a whole.
Well, I think what they're pointing out is that the change would not be a change in the operation of the law, because the same rules would apply. The question relates to how the public sector equality duty arises and how it is actually enforced. And they make the point that data analysis and in gathering information relevant to that is something that needs to shift with a changing dynamic, a changing set of social circumstances, a changing set of group. That's what they're getting at here. So
yes, absolutely. Yeah, and that obviously is clearly understandable when one's looking at Scotland in isolation, that this legislation would represent whether one wants to describe it as a social change or whatever, that would require reaction within Scotland. What I'm trying to understand is how this applies where we're talking about, I'm dreading to use the word divergence because I know it carries a potentially loaded meaning, but a difference emerging between two jurisdictions within the United Kingdom. Because, for example, at paragraph 39, they say even if the adverse impacts comes above were compelling, which they're not, they relate not to the operation of the public sector equality duty as a legal duty in itself, but rather to the perceived practical difficulties of applying an existing unchanged set of legal principles post-reform. I know this is not, but is that not a change in the operation of the law?
It's not a change in the operation of the law, because the law doesn't change. And the way in which the law is applied doesn't change. There may be different considerations in the way that the public sector equality duty is applied, but that doesn't mean to say it's an adverse effect on the operation of the law. There has to be not just an effect, but an adverse effect.
And yes, that's quite right. It's got to be adverse.
What is really important to see is what the Secretary of State has said in 7B. He says the public sector equality duty would have to apply the public sector duty different as regards Scotland and England and Wales. It doesn't say how, and how that would have an adverse effect on the operation of the law. And at 12B, he says Section 149, public sector equality duty, an increase in the number of people holding gender recognition.
I'm sorry, I missed it. Where are you, Lord?
12B,
12B
in the
sorry.
order, will make it more difficult to monitor UK-wide disparities between women and men, or transgender or non-transgender people, if membership of those groups differ between Scotland and the rest of the United Kingdom. But he doesn't say how and why. It's just not good enough to make these assertions without explaining in cogent detail why. And I think what's really important is to understand that the Secretary of State's concern about gathering data is undermined by the fact that the vast majority of official data is currently collected on the basis of self-defined sex. And that's something that was explored in detail by the Scottish Parliament and by reference to guidance published by Scotland's chief statistician, which is referenced at PDF 482 of the petitioner's marked up bundle. So the issue of data collection was explored in detail before the Parliament, and there was no difficulty identified. And the Secretary of State doesn't deal with that evidence at all. Indeed, as Equality Network says in its written submissions at paragraph 2 and 3, there are very few situations where having a gender recognition certificate has a practical effect. So it's really important in my submission, my lady, to have regard to the evidence before the Scottish Parliament about data collection and the position taken by Scotland's chief statistician. There was an expert group set up by the chief statistician on this, and the minister, Miss Robinson, explored the detail of this in the letter that she sent in draft to the UK government to respond to one of the submissions from the UN reporter on violence against women and girls. It really deals with it in detail. And so one should really compare and contrast the depths of the analysis that's been done by the Scottish Government, the Scottish ministers, and Scotland's chief statistician against the work that's demonstrated in this order, which is wholly and utterly inadequate.
Wholly and utterly
inadequate.
Inadequate.
Lastly, on the matter of schools, the concerns expressed focus on the effect of the bill in requiring single-sex schools to accept transgender pupils with GRCs. Given that the Scottish Gender Recognition Certificate is only relevant or legal in Scotland and not acknowledged by the UK government, the question relates to the 6 single-sex schools in Scotland and the number of occasions in which this problem, if it be a problem, I say, given the fact that there's 6 single-sex schools in Scotland, the number, the occasions that any difficulty is likely to arise will be very small. And the Secretary of State doesn't explain how single-sex schools currently deal with applications from transgender pupils, nor does he produce any evidence of such schools being concerned about the prospect of the bill's entry into force. There was no concerns raised in the passage of this bill through the Scottish Parliament by independent schools in Scotland. None. And as I have already...
So far as you're aware, the only single-sex schools are independent schools, is that right?
As I understand
local authority.
Yes, 6, and I think there's 6. I'll double check that fact.
At one time, I think there were some local authority schools that were single-sex, but that may no longer be the case.
Yeah, I'll double check that, lady. As I've already explained, the concerns about the impact on IT systems are speculative. They are also inadequate given the UK government raised no concerns whatsoever about the technical feasibility of a dual system for gender recognition when consulting upon England and Wales only reforms. For an informed reader to understand why those concerns now require that the bill be vetoed, it's necessary for that reader to understand why and when the previously practical became impracticable, when the previously possible became impossible. And I've also explained it's very difficult, if not impossible, to work out when this could present a real issue for the administration of the tax and benefit scheme. If Scottish ministers, with the benefit of special advice, which we have had, cannot understand the concern, it cannot be said that an informed reader would be left with no real and substantial doubt. In relation to other reasons that are irrational, that is so in relation to the concern about the system for overseas citizens to obtain Scottish gender recognition certificates at paragraph 9. As matters stand, several countries with self-identification systems of gender recognition are on the approved list under the Gender Recognition Approved Countries and Territories Order 2011, which is at page 335 of the PDF. So currently, there are approved countries and territories in relation to gender recognition who operate self-identification systems, and it's difficult to see what the difficulty is now from the Secretary of State's perspective. What is now said about the UK government's intention to revise that list, the 2011 order, it does remain in force and has done unamended for some time. And the Secretary of State raises no particular issues arising from the current system for overseas recognition.
As I understand it, and Mr. Johnson might forgive me, I'm going to put this perhaps rather inelegantly, but I think, as I understand the concern in summary, it's that on this issue, Scotland could be seen as effectively something of a soft touch or an easy route in. So whereas currently a 17-year-old from a country on that list could not use or would, when it was some difficulty, would be able to use the current regime, they could enter, in effect, through Scotland and make use of the revised Scottish system, and then thereafter they're within the United Kingdom. That, as I say, is rather inelegantly summarised, but I think that's what I understand one aspect of the concern to be.
I'm interested in the language that your ladyship uses.
Don't use my language.
Good possible, but the point is, and this is what's important about the interventions and indeed the evidence before the Scottish Parliament, is that there are numerous countries on the list where self-ID is a system, and what I'd need to check is the age at which self-ID is permitted, because some of the countries it's at age 14, and I'd need to explore that in a little bit more detail to come back on what countries on the list allow those under the age of 18 to self-ID, and I can come back on that. But this is a difficulty, though, that we have with the Secretary of State's reasoning, which doesn't explain what the adverse effect on the operation of the law is. He can look at possibilities, hypotheticals. He can say, I'm a bit worried about that, but it has to go far further than that for all of the reasons that I've touched upon in my submissions. So in relation to the Secretary of State's assessment of the adverse effect on the operation of law as it applies to reserved matters contained in 4 and 6 to 12 of Schedule 2, each and every one of those paragraphs is flawed in at least one of the ways I've just set out. and the reasons are thus inadequate in law, and the orders ought to be reduced. As well as disagreeing with my submission that the reasons are flawed, I suppose the Advocate General might say, for this ground to result in reduction, all of the reasons have to be flawed. I don't accept that. If your ladyship is satisfied that some, but not necessarily all of the reasons are flawed, it will be necessary for your ladyship to consider whether the effect of the flaws is such as to undermine the decision to the extent it cannot stand. If only a handful of the reasons survive, it is open to your ladyship to conclude that the order cannot safely stand, given the extent to which the Secretary of State has erred. So if your ladyship gets to a position where some but not necessarily all of the reasons are found to be inadequate, I would suggest there are two options. First, your ladyship may be clear as to whether what has fallen is sufficient to vitiate the order or not, in which case your ladyship can simply give effect to that view. Alternatively, your ladyship could ask the parties to provide further submissions based on your ladyship's conclusions. In the first instance, at least, such submissions could be written. In short, however, my submission is that if reasons start to fall, a point will quickly be reached where there's a critical mass and the order cannot survive. That point, in my submission, is only reached when the last reason has fallen, is not only reached when the last reason has fallen. So while, in conclusion then, my lady, while the subject matter...
I think the Advocate General says the opposite, that he only needs one, to put it crudely, one to stick, and because the order says, I think, in terms that it's separately and cumulatively. So it may be, Mr. Johnson might correct me, but it may be that he says that I only need to get across the line on one, and even if everything else falls, that's enough.
Yeah. Well,
you say no.
He might say that, but I think that what I would say is that your leadership really has to approach this very significant issue by reference to the appropriate standard of review, by reference to what has actually happened here, which is an executive override of a lawful decision by the Scottish Parliament, and in relation to whether or not one reason itself is sufficient, it can't just, you've got to look at it more than at face value. You've got to understand what the import of it is and the extent to which it will have an adverse effect on the operation of the law in relation to reserved matters.
I certainly agree. In amongst a number of difficult issues here, this is a difficult one. I'm not clear. I think you described as if the reasons started to fall at some point, then one would reach a critical mass at which the whole order, that's if I don't go with your primary submission that the whole thing is flawed, but if the reasons start to fall, can you help me? What is that critical mass? Do you know, or do you have a view on that? And do any of the authorities that are lodged assist with it? Because I say it seems to me on the face of it that perhaps, as might be expected, the parties are taking divergent, use of that word again, divergent views of the approach here. You say that a point will be reached at which the whole order will go. Mr. Johnson may say, if there's one cogent reason, even if I were to reject all the others, that would be enough to sustain the order. Are there any of the authorities that assist on this? Well, as far as you know,
my submission is you shouldn't accept that the assertion at face value that one reason's enough. But my lady's raised a point that I can reflect on and come back if there's other authorities on that. We'll look to see if there's other authorities.
I accept it's a very important point, and as I say, if there are, if the views do diverge meaningfully on this, it would be helpful to know.
Yes, I see that. Just 1 second.
Yes.
Yes, okay, okay. I think we'll come back on that. I think, if possible, my lady, we could come back on that particular point, but my lady has all my submissions about the standard of review and the way in which you should analyse the Secretary of State's reasons.
Yes, again, I apologise, interrupt you. You've been your submission. I think it got to the point where you were reminding me of the appropriate. I need to consider the appropriate standard of review, and that what has actually happened here, which you characterise as an executive override of a lawful decision of the Parliament, and that was the point you'd got to.
And so that if the point's reached that only one of the reasons stick, as my lady's put it, is really not good enough to say, well, that's the end of the matter, because you'd have to question whether or not just one of the reasons would have meant that the Secretary of State would have still made the order. So I'm not accepting.
It may depend which reason it is.
Exactly. So I'll look again at authorities on that, my lady, and I'll come back on that point. But I think it's critical to your ladyship's decision that she looks at the reasons, and if the Secretary of State has gone wrong, then we just shouldn't accept that one reason would be enough, and maybe one reason's he's not gone wrong, then that would be enough to say that what he's done is lawful, and he would have just done the same thing anyway. So I'm kind of repeating myself there. I'll think about the proposition that your ladyship's raised, and I'll come back on that if I can, with authorities in addition to those that have already been put before my lady. So I have to get the information from online that shows the way in which passports are obtained. I'll get the information that relates to the number of gender recognition certificate increases UK-wide, following upon the changes that they've made, and I'll look at the authorities on that particular point if I can come back. And so then what I'd simply do now, ladies, conclude at this stage and say this, that while the subject matter of the bill is gender recognition, this case raises and turns upon important questions about the constitutional arrangements of the United Kingdom. Under those arrangements, the Scottish Parliament has an unquestioned democratic mandate to make laws within its legislative competence, which it considers appropriate for the people of Scotland. It is inconsistent with that basic constitutional structure which was enacted by the UK Parliament to recognise a broad and largely unfettered power to block the legislative choices of the Scottish Parliament. The UK Parliament cannot, for the reasons I've set out, be taken to have intended to enact such a provision. At the time of the enactment of the Scotland Act, the power under Section 35 was one which was understood would be exercised only as a last resort and under the supervision of both the UK Parliament and the courts. The court should therefore subject its use to close scrutiny. And I say if the court does that, then for the reasons I've set out in my submissions, it should conclude that the conditions that must necessarily be fulfilled before an order under Section 35 have not been satisfied. That being so, your ladyship is invited to sustain the Scottish Minister's first, third and fourth plea in law and repeal the Advocate General's pleas in law and to reduce the order. And other than the issues I can come back on, those are my oral submissions. Your ladyship has a note of argument, the petition and all of the documentation that's been put forward in support of this case.
Thank you very much, Lord Advocate. Now, Mr. Johnson, I'm happy to hear from you. We are making good progress in this case as against the timetable that was set.
Yes.
It is just after 3:30. If you wish to begin now, or alternatively, if you have a submission to make that you require some time to reflect on submissions, I would certainly listen to that.
I'm perfectly happy to make a start now, my lady.
Very well.
Perhaps for 15 or 20 minutes.
You might have some introductory remarks to make.
Yes. I begin by inviting your ladyship to refuse the petition, and I adopt the note of argument, to which I will add some further submissions, mainly in the course of tomorrow. I wonder, before I come to the point at which I was intending to begin, whether in relation to the issue you, my lady, was discussing with the Lord Advocate a moment ago, I could direct your ladyship to one authority. And I will come back to it, but it's perhaps helpful to have it before the court.
Confess, I have a feeling I've read something somewhere, but there was quite a lot to absorb, as you can imagine. Yes. So I didn't want to trust my own recollection.
I'm sure my lady has pinpointed the one that I have in mind. It's in the reserve bundle, page, I think it's page 708, but the relevant passage is at 723 of the reserve bundle of authorities.
You just bear with me. Mr. Johnson, so you can just get that up.
It's called Holmes Moor House against Richmond upon Thames, London Borough Council.
So I have the reserve joint list of authorities. Is that the bundle?
Yes, that's it. It should
what
be.
Number is what number?
It should be page 723 in that bundle.
Oh, sorry, 723.
And it's right at the bottom, paragraph 51, the last 3 lines. Your ladyship should have the passage which deals with the point that was just under discussion.
Just bear with me. This is highlighted paragraph 51, is it?
Yes, that's it, my lady. If I could just read it out, because it's quite it breaks down quite usefully the various types of error that arise and the effect that they should have. And you can see that this is in the speech of Lord Neuberger. He says a decision can often survive despite the existence of an error in the reasoning advanced to support it. For example, sometimes the error is irrelevant to the outcome. Sometimes it's too trivial, objectively, or in the eyes of the decision maker, to affect the outcome. Sometimes it's obvious from the rest of the reasoning read as a whole that the decision would have been the same, notwithstanding the error. Sometimes there's more than one reason for the conclusion, and the error only undermines one of the reasons. Sometimes the decision is the only one which could rationally have been reached. In all such cases, the error should not, save perhaps in wholly exceptional circumstances, justify the decision being quashed. And we can see, reading on to the next paragraph, that he points out that in this decision, one paragraph does contain an error, but his conclusion is that it's not an error which in any way undermines the reasoning upon which the conclusion is based. And in my submission, that's really the test that the court is likely to wish to apply to consider the materiality of any error or any failure to give reasons that it identifies. And as Lord Neuberger says, consider whether it undermines one of the reasons or all of the reasons. And so to that extent, we would perhaps be considering the weight or the critical mass, as it was put earlier.
Yes.
But it's very important, and obviously I'll come back to this tomorrow, it's very important to have regard to the paragraph in the order that Milady referred to, namely that each individual reason is set out in the order as a separate ground for making it. So they do not stand or fall all together, but they have their separate force. And that's one of the situations Lord Neuberger contemplates there.
Thank you.
Going back to the beginning, which is where I normally have started, going back to the beginning, like the Lord Advocate, I'd like to begin with just a few words about what this case is not about. To some extent we agree, but not entirely. I think we agree this case is not about the merits of the policy to which the bill gives effect. But I think that may be about as far as we agree. And that's why, as I'll come on to discuss, this case is not, as the Lord Advocate would have it, it's not about a policy disagreement between the Scottish and the United Kingdom government. The Secretary of State's concern is set out in the reasons in the order under challenge. And his concern is that if enacted, the bill would have adverse effects on the operation of the law as it applies to reserved matters. And I think there are two important points I could make here about that. The first is, of course, as the court knows, that that's a matter entirely separate from legislative competence, and it arises under a different provision in the Scotland Act. And it's for that reason the order was made under Section 35, and it's the validity of the order in terms of Section 35, which is the sole issue here. So that's the first point. The second point I think it may be helpful to make here, and I will come back to it, is that throughout her submission, I think it's fair to say that the Lord Advocate is assuming that the Secretary of State ought to have been conducting the same kind of exercise that the Scottish Parliament was conducting. But in my submission, it's very important to understand that he was not doing that, and that is not his duty under Section 35. His concern, rather than with policy making in Scotland, his concern is to protect the United Kingdom, or rather to protect the interests of the United Kingdom, if he identifies adverse effects on the operation of the law as it applies to reserved matters. So the focus of his consideration and the focus of the reasons given for the order is going to be very different from what the Scottish Parliament put out in their own published discussions or in the report of the lead committee, for example. So that's the only other point I would make, that the concern is a very different one, and that is reflected, as we'll see, as we go throughout the course of my submissions. The way I'd like to break them down is firstly to begin with a section on the law, on the framework for review, which will cover the various points about intensity of review that have already been considered today. And then, having done that, I will come on to the evidential question and look at the various grounds of challenge which have been set out in the course of today. So the first of those sections then is about the framework for review, and I take this from a line of mostly very well-known cases which indicate the approach that the court should follow. And there are eight points, some of them quite long, so I won't get through them all this afternoon, but start with some brief ones. First uncontroversial one is that the interpretation of Section 35 is naturally a matter for the court, and it's the court's role in interpreting this Act, the Scotland Act, as any other, is to give effect to the ordinary meaning of the words used in the section. And in case authority is needed for that, it was spelled out in the Continuity Bill case in a passage which I don't think we need to turn to. But it's Continuity Bill paragraph 12, and it's page 534 in the core bundle. So really my first proposition is that the concern here, following a line of cases where there was some discussion about whether constitutional statutes had to be treated in a different way, it's made clear by that case that they don't. The concern is to give effect to the ordinary meaning of the words used. The second point, again, this is a straightforward one, which I, to some extent, anticipated. There are checks on the legislative competence of the Scottish Parliament, and they're built in sections such as 29 on legislative competence. But that's not the only check on the powers of the Scottish Parliament. And as my lady knows, this case is not about legislative competence. So that brings me on to my third point then. What is Section 35 about? It's a key feature of the devolution settlement. And it's of a character different from the enacted rules governing legislative competence, but it's integral, I would submit, to the constitutional distribution of power in the Scotland Act. So putting the same point in a different way, it's an express recognition on the face of the Act of the possibility that devolved policy or a devolved bill, a bill in touching on devolved matters, may have an adverse impact on the operation of the law as it applies to reserved matters. And so, just developing that point
I think
slightly.
that was explicitly recognised in the passage quoted from Hansard, I think, to Sewell, the quotation, I think, that's in the Lord Advocate's
yes.
speaking note. I think that the discussion, the debate at the time explicitly recognised that was the thinking behind the clause that then became Section 35.
Yes, I think that's right, Milady. I should say, just for, in passing, that it's our position that it's not appropriate to look at those Hansard extracts, but it's fair to say that there's nothing very remarkable in them that I think would tip the balance either way.
I suppose it depends. We perhaps should just flesh this out over here. I suppose it depends on the purpose for which one is looking at them. If it's simply as a record of what happened, that might be unobjectionable.
That would be unobjectionable.
And I didn't understand the Lord Advocate really to be taking it much further than that, if at all, other than just confirmation of what was said when.
I think I had understood her to be seeking to draw from it some propositions such as this is a long stop power, and that's going beyond matters of fact.
All right. You'll maybe come to that.
Yes, I will, because just to anticipate what I'll come to tomorrow, in Pepper and Hart, we need to find an ambiguity, as is common ground. We need to find an ambiguity before we can start looking at ministerial statements in Parliament. Now, the Lord Advocate says there is an ambiguity, but I did not myself manage to identify what it was in the course of her submissions. So it remains our position that the conditions for Pepper and Hart use of ministerial statements in Parliament are not met. And I probably won't have much more to say about that, but I will come back to it in tomorrow in the place in the argument where it belongs more naturally.
Sorry, I think you'd made the submission that it's an express recognition in the face of the Act that the devolved bill may have an adverse impact on the operation of the law.
Yes, I was simply going to develop that point slightly by emphasising that there's nothing sinister about this power. This is part of the scheme. It cannot be emphasised too strongly that it's part of the scheme of the Act. It's part of the machinery by which government in the United Kingdom operates. And so that on the one hand, it enables the Scottish Parliament to work within its competence. And on the other hand, it empowers the Secretary of State on limited grounds to intervene when there's a concern about adverse effect on the operation of the law applying to reserved matters. And if that's the case, then we can see from reading the relevant section that the United Kingdom government then has power to intervene to prevent the legislation being submitted for royal assent, even though it's within legislative competence. So my third point then really is just to emphasise that that we need to understand that this is, and indeed Hansard says this, if one were allowed to look at it, that this is part of the scheme as a whole. It's nothing. It's not an unusual provision. It's part of the whole scheme, and the whole scheme is meant to work together. And I think I can fit in one more point, and then perhaps it might be if we have time. So my fourth point, Milady, is simply to say this: that the nature of the power which is conferred on the Secretary of State under Section 35 determines the nature of this court's function on a challenge such as the present. And it's quite simply to apply the language and the structure enacted by Parliament. And at the risk of saying things that are too obvious, I'll say this: the court's function is not to act as the primary decision maker. We know that that primary decision making task has been given to the Secretary of State. So the court's function is one of review. That's to say the usual public law control of rationality. Now, I will come in my next point, probably tomorrow, to look at the intensity of review cases, but it's true to say that the language used in the cases has developed, so that we've moved perhaps somewhat beyond Wednesbury and CCSU in their referring to decisions so outrageous in defiance of logic or accepted moral standards that no sensible person could have arrived at the decision. More recent cases are more likely to use the language of whether the decision fell within the range of reasonable responses open to the decision maker. And I'm quite content with that as the formulation. We'll find that in cases such as Kennedy, to which I'll come later. But that still preserves the clear sense that the function of this court is review. It's looking not to see what it would like to do, but it's looking to see whether the decision maker made a decision within the range of reasonable responses. And in no sense is it arriving at a conclusion on what the court would have decided for itself. And finally, under this heading, there's just one further point to add, that it's consistent with the function of review, that the decision ought to be reviewed on the basis of the material which was before the decision maker. And there's a case in the main bundle, Siclowry against Secretary of State for the Home Department, a decision of Lord Brodie, which Milady has 983 in the main bundle, paragraph 13 of the report. We probably don't need to turn it up, but if Milady wishes to do so, it's in the core bundle 983. And his lordship says there, a consequence of the nature of the supervisory jurisdiction, as well as of logic, is that the rationality of the respondent's decision must be determined on the basis of what was before him at the time the decision was made. Then he says, counsel for the petitioner seemed to suggest it was irrational for the respondent to conclude that on any legitimate view the human rights claim would fail on appeal, when in relation to what was a very fact-sensitive issue, the respondent was not in a position to know precisely what evidence might come out in the course of a hearing before the tribunal and how it would assess that evidence. If that was his suggestion, it was wrong. The rationality of a decision is to be tested by reference to the material which was available to the decision maker when he or she made his or her decision, not by reference to material which might become available to a different decision maker at a future date. So, Milady, the point in raising this issue is simply because there's quite a lot of material before this court, produced not least by the interveners, or one of the interveners. There's quite a lot of material that was not before the decision maker when he took his decision. And in my submission, it's not appropriate for the rationality of his decision to be assessed in light of that material for the reasons that Lord Brodie gives. Of course, it's another aspect of the argument to which I'll come tomorrow, that of course, it's accepted on this side of the bar as well that the Secretary of State has to comply with the Thames side duty, so that he does need to have material before him to make the decision.
Yes, because no doubt you've understood, Mr. Johnson, that part of the Lord Advocate's criticism is that the Secretary of State didn't make sufficient effort to have material before him that he could, or I think the Lord Advocate say ought to have had before him. So you'll appreciate that's a point that's made.
I do. I'm sure it's a point that's of interest to the court, and I will deal with it fully tomorrow. If it's convenient to the court, I think
Yes.
this might be the most logical place to
Very
break
well.
off at the moment.
We'll rise for today, and we'll begin again tomorrow at 10 a.m.
Thank you, Lady.
What?